Welcome to the courtroom for the case of Silver State School District v. Portnoy. We're starting at 10:29. We will start with opening statements. Prosecution, you may start.
And then a quick point of information. Would you guys like me to sit or stand for the speech?
Stand.
Okay.
Please sit for mic purposes. Thank you.
Of course. Okay. And then my time will begin on my first word. Hello, my name is Attorney Abraham, and I'm here to represent the plaintiff, Ms. Portnoy's testimony regarding the breach of her First Amendment constitutional right. We will be utilizing the Pickering test as a basis for substantiation and a leading framework to argue against the secession of constitutional protections in government spaces. Logistics can be provided upon request. The plaintiff's state-centered concerns derive from ongoing litigations surrounding a newly constructed academic program. The plaintiff, a middle school math teacher who holds the highest executive position in her department, was not consulted prior to the implementation of the Core Link curriculum. The Core Link curriculum has historically inflated academic performance and discredits the empirical studies of traditional methods. Nonetheless, Principal Skinner, the standing executive director of the school, had ratified his practice regardless. Because of the imminent public concern this program could impose upon families and students alike, the plaintiff took the forefront in dismantling it, including releasing a thorough booklet with the logistics of the program and what discretion is required before enrollment. The school chose to solely take action against the distribution of these booklets during the open house period, which is appropriate in the plaintiff's contract as follows, and is also additionally appropriated within this following statement. Open house. To allow parents to review their children's work, to discuss with parents their children's achievements and progress during the year, and to discuss with parents the student's curriculum that year, and to give parents an opportunity to view the classrooms. The academic institution, overseen by Principal Skinner, had promptly reprimanded her efforts by demoting her executive position and taking other measures that are indicative and complicit of firing. The school's legal framework addresses her constitutional right as null and void. Moreover, given her position in government service and the alleged threat her advocacy held against the success of the academic institution, the plaintiff will introduce the Pickering case, which conditions the validity of broader federal policy. Upon satisfying two tangible requirements, government service workers can retain their amendment right even in positions of service. The conditions are as follows. First, the court must determine whether the employee's speech touches upon a matter of public concern. And second, if the court determines that the speech is of public concern, then the court must balance the employee's interest in commenting on matters of public concern against the public employer's interest in promoting the efficiency of the public services it performs through its employees. Per the legality of the case, the opponent will lose if they fail to prove how the plaintiff's comments weren't of public concern and how the plaintiff's standing obligation to inform community members about circulating policy is non-topical to the mobility of the institution. Because the booklets were of public concern, and because the plaintiff's interest on retaining curriculum-driven advocacy were of a greater priority than the school's interest to mitigate minor discourse, the plaintiff seeks reimbursement under the breach of the First Amendment, moreover, having to reinstate the previous firing and demotion, as well as a fiscal reimbursement fee as well. I rest my case, and thank you for the ability to come and testify. Thank you.
Thank you, Mr. Abraham. Now, Mr. Kung, you may start your opening statement.
My opening statement is short and concise. It consists of two reasons why Mr. Springer was justified in demoting Ms. Portnoy. First, education is the backbone of America. Trust in that backbone is the back brace. It's the foundation of all meaningful connection, both professional and personal. So when a teacher publicly defies a ruling of a public acquisition, in this case, the established math curriculum, that trust gets broken. Why trust a school when their own teacher is criticizing it? Especially when DA Abraham says she is the highest executive decision member. Remember that. When thinking of your deliberation at the end of this trial, remember we ought protect the backbone of America, education. A 1% risk you think Ms. Portnoy jeopardized our education system means you ought vote against her in the name of education. The second part, we wish to sue the prosecution for $50,000 for defamation of character. Ms. Portnoy had no reason to publicly scrutinize our school board's math curriculum, but decided to do so anyways, calling the principal's work a pile of garbage, clandestine, amongst other vulgar language, devastating the reputation of Mr. Stinger. As a teacher, you have power, and especially as the highest executive decision in that branch, you have power, and you have a responsibility to protect the education of the new generation. Ms. Portnoy failed to do so when she publicly ousted Mr. Stinger's disagreed that was already established. The Pickering test. The court must ask two questions. DA Abraham went over them. One, is it a matter of public concern? The first reason is that no. The board already decided and already talked about the stuff she was complaining about and decided not to vote in her favor, which means the interest of the government was tested against hers and she lost. Remember that for a second. The interest of the government and the public supersedes her own interests. I rest my case.
Thank you, Mr. Kung. We will now.
A quick point of information, would we then proceed to verbal rhetoric, or what would be the next course of action?
We will be beginning oral argument now. Prosecution, you may start.
Am I allowed to also additionally request about 1 minute and 30 seconds of prep time?
Yes.
Okay. My time will begin now. Quick point of information, has my time of prep ended?
Yes. Now begin your oral argument. Thank you, Mr. Abraham.
Okay, my time will begin on my first word. So me and the defendant both conceded with the principle and framework of utilizing the case of the prickling to outline the framework of the case. Therefore, must prove in order as to why the Perkins case should be the highest priority. Again, we conceded to that, and now we will follow in the list. We will first prove why the program inherently is of public discourse and also stimulates detriment upon that, and then we will also prove why the plaintiff's call to action and why the plaintiff's request for its dismantling outweigh the interests of the government. Before we begin, we are first going to address my opponent's rhetoric as well as the flow and prompt a rebuttal. Let's first start with my opponent's first case and in his first rhetoric. So, he discussed two reasons as to why Mr. Skinner was justified. One, he discusses why education is at the forefront and the backbone of America. He also talks about why teachers should not publicly defy it, as it is fundamentally ought to be protected and ought to be reinstated. The problem with this is that if education is truly the backbone of America, then its government employees and anyone serving it has the obligation to contend meaningfully. Ms. Pointer, or the plaintiff, did not instigate defamation. She did not instigate detriment. And she did not instigate anything that would otherwise bombard the school with a bad or untangible public image. Instead, her goals and her ideals were not only about dismantling the system at hand, but also consulting parents and faculty alike as to why the logistical aspects of this proposition will not only impose detriment, but also stagnate mobility within the educational institution. If education is a backbone within America, then all employees serving it have an obligation to improve it. Moreover, again, ought to protect education. My opponent would also like to sue the prosecution again, saying that they had no reason to scrutinize the logistics of the bill or logisticize the program itself, though there are many tangible reasons, a myriad of reasons at that, as to why this program should be dismantled, and why the prosecution and why the plaintiff took those initiatives to do so. The first is that it does not look at student performance holistically. Two, her expertise and her seniority was not consulted before its implementation. And three, it also stagnates and inflates academic performance. These are all claims, and these are all rhetorics, and these are all contentions that my opponent failed to bring up, as well as failed to address inherently. Before proving the logistical aspects and the validity of the Perkins case, we would also additionally have to prove as to why the program has the backing itself. From this reason alone, government employees, as well as anyone approaching the case, has an obligation to dismantle anything at hand that would otherwise impede the ability of the school to do anything tangibly. And again, Ms. Poiney publicly outed Principal Skinner. That is also something that I personally would concede to a certain extent. Right? When we consider public outing, it is in the best interest of the school. The original booklet at which the opponent is suing and with respect to did not include any derogatory behavior. It did not include anything that would also impede the message of the school. It would also include nothing that would otherwise, again, impede the mobility of the school. Instead, it was simply a redirection, informing faculty as well students and parents at the open house about how to approach this program and what they should do if they do value the educational might of their students. Moreover, my opponent also establishes why the government, in essence, has a higher view of moral compass, or they have a higher interest within this case, therefore proving the second point. What I would say to that is that just because a government entity testifies against an individual does not mean that their individual ambitions or their intent is automatically weighed higher than another, right? That is not only constitutionally distressful, but that is moreover non-topical to the conversation as well, because everyone, regardless of the body, is entitled to the same constitutional right. And again, the goal of the school or institution was to mitigate minor discourse, whereas the plaintiff, their goal and ambition was not only just to mitigate minor discourse, but also improve the mobility and the academic integrity of the school on the behalf of not only faculty, but teachers alike, as well as the logistics within the domestic classroom itself. If I don't know what is held within the best interests, then I genuinely don't know what. Her interests were very, very tangible. Next, I would like to also reinstate and revalidate what the claim at hand would be, and just to reiterate arguments yet again. So we have to understand the logistical component of what program was integrated and how it affects faculty and students alike. Again, the holistical aspects of the proposition was inadequate, quite frankly. There have been no remarks on behalf of the opponent nor the faculty to provide backing as to why it works, as to why it is the best option, the most concrete option for families alike. And again, given her expertise and given Ms. Pointy's seniority within the field, she knows best. And she wasn't consulted when we are considering any sort of affair. Grade inflation is a very, very tangible component of this entire committee, and we have an obligation to reinstate education within America as well, which is the primary obligation of not only the plaintiff but this entire committee as well. Moreover, I would also like to just again reiterate some components of the opening statement in very, very vague terms. So, again, the school's legal framework, as outlined within the case, nullifies her constitutional amendment. That is exactly why we are testifying here. We're talking about the constitutional amendment. My opponent is making the claim or implying that when you are in government service, you automatically secede your constitutional right. Or when you are not proving that the issue at hand is of public discourse, then you are not entitled to that constitutional right whatsoever. We have to discuss what the open house means on her contract, and we have to also discuss what she did in accordance to that. So just to read the open house policy on her contract yet again, open house to allow parents to review their children's work, to discuss with parents their children's achievement and progress during the year, and again, to discuss with parents the student's curriculum that year, as outlined within the contract. The booklets given within the open house discuss just that, and the core curriculum implications as well strongly align with the curriculum itself. Therefore, it is considered a topical statement. When she is acting within the best interest of both faculty and students alike, she is not insinuating derogatory behavior, but instead facilitating contention and backing those statements as well through a holistic analysis, which is exactly what she did. The booklets at hand were not inflammatory. The booklets at hand did not impede the mobility of the school. Rather, what they did was not only prove why the core curriculum was inadequate, but why traditional systems built upon empirical evidence are the most tangible form of reference that we can cite within this committee. Moreover, just to finalize, we would then prove how the court would thereby determine how her issues were weighed against the interests of the school. The school, all they were trying to do is mitigate minor discourse amongst their faculty. There are no other interests laid out by the contention. There are no other interests laid out by the school itself. Minor discourse and mitigating defamation amongst their faculty was their only and primary goal. Whereas the plaintiff, their goal, again, to reinstate adequate educational values within the school as well as the broader committee, actively detesting and highly encouraging parents to revoke this idea entirely. Not by force, not by any sort of thing affiliated with such. And again, if she was insinuating inflammatory statements, if she was trying to instate such an inflammatory enterprise, then why would she be on the grassroots? If she wants to make tangible change within this committee, within the school, then why would she instigate inflammatory behavior? That is completely redundant, and again, I would consider that an educational scrutiny within itself. If you are trying to amend something, if you are trying to solve something at the root, you must confront it holistically, and you have to avoid defamation. And again, my opponent also isolated the statement that she criticized the school board, calling them a hot pile of trash. I don't believe that is topical to the open house statement, which is what the opponent is directly testifying against. And I don't believe that she directly meant to state that on behalf of anyone to any extent. All booklets given on the behalf of faculty and all booklets given on the behalf of parents and the public alike have avoided derogatory behavior and have avoided an inflammatory enterprise. Like I said, we are discussing the First Amendment. As I discussed, she has a tangible course of action to testify against this policy. And moreover, just to finalize, her interest of trying to retain educational mobility within the institution should be held to the utmost priority. We should base our statement based on empirical evidence given on the behalf of senior officials such as Ms. Partney, as well as the plaintiff itself. And I would then yield my time to the chair. Thank you.
Thank you, Mr. Abraham. Mr. Kung, you may now begin your oral argument.
Point of information, I think Mr. Bowles said that we would do the countersuit after. And then also, I would also like to request a minute 30 of prep time.
Yes, we are doing a countersuit at the end of this, and then, yes, you may have your prep time.
Thank you.
Point of information, what would then be the next course of action? Would we empower witness testaments as well, or? Yeah, after my speech. Okay, phenomenal. Thank you.
Mr. Kung, please begin your oral argument.
Remember that a 1% risk our belief in education is threatened, you ought to reject and protect the backbone. The Pickering test asks 2 questions. The first tier or threshold question is whether the speech at issue relates to a matter of public concern. A yes to this answer to this threshold triggers the second tier of analysis, balancing the interests of the employee and the government, but it does not decide the constitutional question in the speaker's favor, which means that the threshold for the second question is for the DA to win the first, but I have substantive defense as to both. The first question, is it a matter of public concern? No, because the board already decided it. The school talked about the stuff that she was complaining about and decided to not vote in the way she was leaning, which means the interest of the government was tested against her own interest and she lost, which means it is not a matter of public concern. The second question is about balancing the government's favor, which means she lost that debate. She lost the first question and the second question. Now the other question is the question of were you speaking as a private citizen to do something? Because if you are not, then you are not obligated to be protected under the First Amendment if you are a public servant. She was on contract time at open house, which means she was a public servant and was a teacher at that instance. Statute 511 U.S. at 672 specifically says the Supreme Court declared that in Pickering that a government employer can restrict the speech of its employee without offending the First Amendment if the government's interests in efficiently carrying out the public services outweigh the interests of the employee in speaking as a citizen on a matter of public concern. Which means that when her interests were tested against against the government's education system, she lost, which means it superseded her own interest. I'm going to go down the line now. She said that education is to contend. We ought to contend. He said that we ought to contend meaningful education, but it was not meaningful because, again, I said that the reasons she opposed to were already talked about and decided to not vote. Now they say then he says the prosecution says that no student performs intellectually differently. They're all claims, though. The prosecution already admitted that they were all claims, which means it's not actual evidence as to it's not actual offense or defense as to why the Pickering test is failed. Now, the second option, the next thing the prosecution says, is that it impedes the mobility of the school. But if you've already established that she's the highest exec position, and she was not in that decision, she was not in the oral decision about the curriculum, either that means she wasn't actually the highest exec, or that her exec position was tested and she lost again. But if she is the highest exec, that means she has the most influence over the curriculum and the parents who trust her, which again goes to my point that there's no reason to trust a school when their own highest teacher is criticizing it. Now, then the prosecution says that we ought to improve the domestic ability, but we already talked about improving it, and they ruled against it. Then the prosecution says that if you are a public government, he claims that we say that if you are public government, you do not get those constitutional rights. That is the whole question of the Pickering test, which I've established. They fail because the board already decided over it, which means her interests were tested against her own, the schools, and she lost. Then they say that she wanted to help and prove as to why it was inaccurate. Then why didn't she say that? Why didn't she say this is inaccurate and this is bad? Why did she call it a pile of garbage? Why did she call it clandestine? And use other vulgar language. Then they say that we ought to mitigate minor discourse. We've both agreed that the education is the backbone of America, which means a 1% risk our education is at risk. You ought to elevate any discourse to a serious matter and decide whether or not that discourse positively or negatively affects our education system. The prosecution tries to address this by saying the pile of garbage is talking about the curriculum, but the curriculum is built and forwarded by the same principle, which is why we are filing for the defamation suit. If someone said a project you made was bad, they would probably think you aren't that smart, which means there was a direct impact on the ideas and models that the principal forwarded, and the result of how the principal is viewed in the eyes of the public. Now I'm going to talk about why our offense as to why the Portnoy speech was bad. 1, it eroded a close working relationship with Principal Skinner. Again, she called it a pile of garbage and clandestine. If she was actually wanting to improve the relationship, she would say that was inaccurate and talk to her first before reaching out to the public. It impaired Ms. Skinner's ability to maintain discipline and control over his staff. Remember this as a reason for defamation at the next suit. His reputation was ruined because of this. It also threatened to disrupt coworker relations with the school because it caused internal unrest as to whether or not they agreed or disagreed with the curriculum. Our third reason is that it interfered with her ability to perform her duties as the math department chair because she was publicly ousting and criticizing the curriculum, which means the public viewed her as a member who would criticize the curriculum rather than for that model of education. The last reason is that they obstructed the routine operations of the school. Public unrest and public disbelief in the fact that we could get education done made our ability to teach the kids makes our ability to teach kids that much harder because the parents are against what they're learning. I rest my case.
Thank you, Mr. Kung. We will now begin judge questions. Thank you.
Point of information, the plaintiff is going to be directed the questioning period first, correct?
I believe it's just open. I think it's ask whoever you want.
Okay. Phenomenal.
I believe it's judges who ask the questions, correct? Okay.
Okay, thank you.
So, just to clarify, is it Miss or Mrs.?
Miss MS for the sake of this.
Thank you.
chamber.
Miss Portnoy, is she the highest teacher rank in the school, like the highest regarded teacher in the whole school, or only in the math department?
Only in the individual math department.
Okay, thank you. And just to clarify, her only public outreach was speaking to like public.
Can you clarify what public outreach refers to?
Sorry.
May you please clarify what public outreach refers to?
As in, oh, sorry, I don't know what you mean. Like she only spoke to news outlets or like newspapers, like local in the.
She spoke
Oh.
at the open house event that was open to parents and students.
Was that the only case of public speaking?
Yes, so in terms of like public event settings, that would be the only case. And there have been instances as well where she also consulted faculty. Other than that, there have been no other outlets at which she referred to.
So she didn't speak outside of the school community.
No, she did not.
Okay, thank you. Do you know how many teachers and students or whatever were at the open house?
We can give a rough estimate.
Please do so.
So it was around, give or take, 15 students and a handful of parents. I would say about maybe 8 to 9.
Okay.
Oh, that was on the behalf of witness testimony, who was actually at the open house event, which you will see promptly.
Okay. So you said 8 to 9 parents. Sorry, excuse me.
Give or take, yeah.
8 to 9 parents and 15 students.
Yes.
Okay, thank you.
I'm sorry, just for my clarification, where, could you give me a page number as well as the document that is on?
Yeah, so that isn't on any current document. It is going to be provided by witness testimony in just a minute.
So going back to the Pickering test, in Connick versus Myers, the court ruled when employee expression cannot be fairly considered by relating to any matter of political, social, or other concern to the community, the government official may enjoy a wide latitude in managing their offices. So since they had already voted upon the thing, would you consider this counting towards them not having a ability to fairly express and therefore validating their speech?
I'm going to answer your question based on what I have seen. So practically, in essence, just because a school rules in favor of something does not automatically diminish the fact that the person testifying has a tangible cause for doing so. A school can instate, let's say, segregation, right? That does not mean that it is tangible, even if they come to a unanimous vote. You can still independently testify for the common good, despite what the board may suggest. And again, the only way that the school can enjoy leverage over a prosecution or over any complaint is if they prove that the individual did not have a tangible cause for insinuating whatever they were doing. So for example, if the testaments were accompanied by derogatory language or they did not have empirically backed substance to them, then the government would thereby enjoy leverage as well as the school. But I will illustrate, and I have just illustrated, that that is not the case. So I think I've answered your question to the best of my ability. Did that satisfy your rhetoric? Okay, thank you.
This question is for Mr. Kong. In your oral argument, you stated that the pamphlet and the resulting discourse around it disrupted the routine activities of the school. Can you give some more concrete examples or clarify what you meant by that? How did it disrupt the routine activities of the school?
Yeah, so two ways. One is that it caused internal unrest amongst the teachers because there were some on this side who agreed with Ms. Portnoy and some who disagreed. But I think the main fact is that they already had deliberated on what they had already taken into account when making this decision, that they already deliberated and they already taken account Ms. Portnoy's reasons for objecting to it. The second reason is that it caused public dismay for the parents and their belief in the school system, because you have the highest exec math teacher publicly disdaining the curriculum established by the principal, which means that they do not believe in the ideas that the school system forwards.
Did Principal Skinner have any? Did Principal Skinner? This is for either prosecution or defense. Did Principal Skinner have any, other than his own personal beliefs? Did he have any peer-reviewed study that said that Core Link would be good or could help the students more than the and same thing for Miss Portnoy? Did she also have anything against Core?
So Ms. Portney did possess some documents concerning the validity of the curriculum and program, but she more so had data that substantiated the development of the current traditional system. Regardless, she has been in this position for 2 decades, and her seniority should be put at the utmost priority. Moreover, she wasn't actually consulted during the implementation. And moreover, the principal has no tangible peer-reviewed studies or any data that would affirm its success. Given the fact that there is none, the program is completely bogus. So,
for the principal, the curriculum was established by the school board of trustees and the principal, and they went over the math curriculum and decided that what they established was the best routine of action.
So Mr. Kung, you spoke on how there was public unrest with the teachers, specifically the coworkers with Ms. Portnoy, and the parents of the school. Do you have any specific conversations or any conflicts that may have happened or reported with the teachers and the parents?
Yes, one of my witnesses is a parent at that opening night.
This question is for Mr. Kong. So you stated that the board proceeded to approve the core link program despite Ms. Portnoy's concerns. And you also said in your oral argument that because of this decision, that made this no longer a matter of public concern. Can you explain that reasoning, please?
Yes, I said that she wasn't consulted, but every single reason that she had to object to it was already reviewed. Every single reason she publicly said was already reviewed by the Board of Trustees.
Relating to that, do you have a form or some kind of documented procedural way that the Board of Trustees and the principal came to the conclusion that this system, could you remind me of the name of it again?
Corelink.
Corelink, thank you. Do you have a document that shows their procedure with deducting that was superior to the old system?
No, one of my witnesses is my second witness is a testimony from a school board trustee member. I don't have like documents as to whether or not they just like the reasons they established the old one was worse and why they implemented the new one. But I think that the witness can attest to that.
Yeah, they should. That works. Thank you.
This question is for Mr. Abraham. In your oral argument, you said that being in government service as a public servant does not disqualify you from your First Amendment rights.
Yes.
Were you aware that in a previous court, Garcetti versus Ceballos in 2006, the Supreme Court said that when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for their First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. So essentially, a government attorney's internal memorandum is deemed to be employee speech, and thus Pickering protections do not apply.
Yes, of course. So can you please repeat the line that had the word pursuant in it, just for clarity?
When public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline.
Yes, of course. So that is in reference to if the individual concedes to a rhetoric that would impede their ability to accomplish a task. And what I just proved in essence is that Ms. Portney, she was speaking on the behalf and well-being of students and faculty, and she did not instigate any sort of misdemeanor or any sort of inflammatory enterprise that would impede her ability to teach. And also contextually, it was an open house period. She was not teaching by any means or capacity, despite her being employed at the time. She had nobody to teach at the time. If she had discussed the open curriculum in front of a classroom, then you would have substance to that argument. But in an open house setting that is open to the public, that argument has no basis to validate it. So I hope that answered your question pretty well.
Could you restate that line for me in the question? The line about pursuant.
So this is from Garcetti versus Ceballos. The Supreme Court held that when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline.
So I am aware of the language that Ms. Portney used. If I recall right, or if I see this in the document, it
Yes.
was calling the proposal a pile of garbage. And
Yes.
was that at the open house directly to the parents?
No, it wasn't. So it was not directed to any faculty member, and it is an isolated incident that has no context as to what happened and who she directed that statement toward. So it wasn't in the sense that she impeded or inflamed the school's public image, given the fact that she did not use that language during the open house or any government-related or any educational-related conversation.
Do you know?
She
oh,
did.
apologies.
She did use that rhetoric at the open house, though.
Do you have the document that
Yeah.
states?
If we're gonna look at this at evidence later, we'll bring this up there. But do you know if this use of the terminology "pile of garbage" was in a manner that was directed to multiple people or just one?
Pardon, please repeat your statement. I apologize.
Do you know if the pile of garbage statement that Ms. Portnoy used was directed towards directed to multiple people, like the document that this was in, or in whatever
So
it was used?
when she referred to anything as a pile of garbage, it was in direct correlation with the program itself, not on behalf of any faculty member and or parent.
I'm asking if multiple people heard or saw the language.
I believe so. I would assume so, but again, there is no substance to that.
Thank you.
Do you have any information to the public reaction to those statements?
There is no evidence concerning the public reaction of that statement.
Thank you.
I will answer that as well. One of my witnesses is a parent who was at that open house, so that would be the example of public witness.
Great, thank you.
Just for clarity as well, I also have a parent witness from the open house as well, just for clarity purposes. No.
This is a constitutional question. This is for both Mr. Abraham and Mr. Kong. So, excuse me. So matters of public concern are defined as those issues of political, social, or other concern to the community, and they are different than just matters of purely personal interest. So, both of you, would you mind explaining whether the issue at hand is a matter of public concern, or was it simply Ms. Portnoy's personal interest?
Would you like me to go first, defendant? Okay. So I wouldn't allude it to her own personal interest, given the fact that her salary will remain the same even after the installation of the program. She has no reason to object the implementation of the program if it didn't impede the public good, right? Her seniority affirms this fact. She has been within the department for 2 decades, showing and exemplifying a steadfast commitment to preserving the stability of education in America. I could not find a way that she would do it for her own personal good, as there is nothing that you can do in objection of this program. Like I said, salary remains the same, and all other entitlements also remain the same.
Could you repeat the question?
Thank you. Is the issue at hand a matter of public concern or a matter of Ms. Portnoy's personal interest? Would you like the definition of a matter of public concern?
I'm okay. I actually agree. I don't think there was personal interest to say that the program was like a pile of garbage. I think she was just talking about the content of the program. But my argument is that it has trickled down effects into how the public views like the principal in the school. Which means, so I would say that there is, it is a matter of public interest.
Okay, thank you.
This is for both prosecution and defense. Do you, because the pile of garbage was that sentiment was in a memo to the staff, do you believe that? Do you think that that is a does that create any problems in efficiency in the workplace?
No, not necessarily. It is also important to contextualize the statement when we are referring to anything of discussion and pile of garbage on the behalf of the plaintiff. It is to the policy and it is to the program itself. She wasn't undermining the ability of any administrator. That wasn't in an objective sense, and she did remain quite impartial throughout the entire process. And I hope that answered your question pretty well.
Thank you. And now, defendant.
Could you say your question one more time?
Because pile of garbage was or the memo itself was handed out to staff and they are part of the workplace, do you think that created any inefficiencies in the workplace?
So to answer your question, I first want to say that it was not in a memo. It was on a packet handed out at the school at the open house, and my argument is that yes, it did, because it it triggered internal unrest about like the split decisions between whether they should have implemented it or not.
I'm so sorry. Can I just read out what I'm reading?
Yeah.
Where I see it's in a memo. Ms. Portnoy, sorry, this is in bench. Wait, they don't have it, do they? Yeah, in bench memo. This is on page 1. Portnoy circulated a memo to all faculty and staff in which he further objected to the CoreLink proposal, calling it a pile of garbage. So it was in a memo. It might have also been in the open house, but it was in a memo.
Okay, so it was probably both then, right? Because she said furthermore, like she further did that, right?
Yes.
Okay, because mine says Portnoy's packet, or like my defense packet says that Portnoy's packet printed on the letterhead bearing the school name and her official department chair title contained criticism of Principal Skinner and other Silver State teachers and the school board's decision. She described the CoreLink program as a pile of garbage.
Thank you.
Thank you. We will now be moving on to the prosecution witness cycle. So prosecution, you may bring up your first witness.
Please restate. My apologies.
We are moving into the prosecution witness cycle. So prosecution, please bring up your first witness.
Yes, I would like to empower one of the faculty members to begin with. And then point of information as well, the time for questioning begins on my first word, correct? Okay, phenomenal.
Plaintiff, are you ready?
Yes, I am.
All right.
And then my time will begin on my first word. I would like to empower one of my first witnesses, a faculty member and a strong advocate for the CoreLink program at the facility. So witness 1, I would like you to first say your name and your affiliation to the plaintiff, as well as the educational institution itself.
Good morning. I'm Michael Albert. I teach at the Silver State Elementary School. I'm an English teacher there, and I worked with the CoreLink program to get it started, and I also cooperated with the plaintiff, Ms. Portnoy, to coordinate our interests as far as like our opposing interests as far as the CoreLink program goes.
And can you please explain how the Principal Skinner, I believe, was integrated within this process?
Principal Skinner tentatively approved the CoreLink program, I believe, on April 30th. Without consulting Ms. Portnoy, who is the head, the chair of the math department first. So Principal Skinner tentatively approved it on April 30th, and that was the start of the process.
Okay, yes, of course. So following April 30th, what was then your relation to the plaintiff as well as the program itself?
Following April 30th, myself and other staff members at the middle school were just in informal communications with Ms. Portnoy as far as our interests and what we wanted the quarreling program to look like. And then Principal Skinner, I'm not aware as how Principal Skinner was involved in the process after that, aside from any formal announcements goes.
Phenomenal. And in the school term and semester, have you ever felt just in a bad position emotionally, and have you ever felt personally attacked as well within any instance?
I never felt that way. As far as this process goes, it's pretty standard for teachers to get emotionally involved in changes in faculty and changes in program go. So while this was a definitely emotionally tumultuous process, I never felt personally attacked or like the process or the proceedings going forward were necessarily extravagant.
Okay, phenomenal. An additional question: how would you describe the professionalist atmosphere exemplified by faculty at the school during this entire process?
As far as professionalism goes, that was definitely lacking. Professionalism could have been better. We saw that with the statement that Ms. Portnoy sent out to all staff and faculty members, calling the program a pile of garbage. That's definitely not a professional way to word your opinion or try to rally support for something that you don't want to change. So Ms. Portnoy's professionalism could have been better, but other staff members were conducting themselves in a consistently professional manner.
Okay, so outside that one isolated incident, can you explain any times where professionalism was lacking within the faculty?
I don't think there was any other instances of egregious lack of professionalism.
Okay, phenomenal. I'm just going to ask an additional question concerning the logistics of the program itself. So can you please describe some benefits that it may impose and whether these are empirically backed?
Yes, so as an English teacher, I supported the program because I believe that incorporating STEM and liberal arts programs at the school would have demonstrated significant benefits to every single student instead of just those who were grouped by skill level, which is what we were previously working with. I also supported Principal Skinner's tentative approval of the program because Principal Skinner sought out to change the downtrend in African American and Hispanic students performing worse in math programs than their white counterparts. So I've supported this for those two reasons.
Okay, can you please answer the second part of the question concerning the empirical backing of the program?
As far as I'm aware, there was no empirical backing for the program. And correct me if I'm wrong, please. I believe what was empirically backed was the previous way we had been conducting the math department, which was skill-based grouping.
Okay, and can you please restate that last part of your claim?
The skill-based grouping that we used for the math department at Silver State Middle School was empirically backed.
Okay, and I'm going to ask you another time to just describe the general atmosphere relating to professionalism as well, but the ability of the school to perform the task at hand. So following the plaintiff's decision of instigating a hostile statement, was the general atmosphere still remain consistent, or was it severely harmed to the point where it could not function?
In fact, I believe that actually after Ms. Portnoy was not demoted, I apologize. I believe that when Principal Skinner went over Miss Portnoy's head and made this tentative approval without the math department's approval, this was when we started to see, as a faculty, procedural, like a decline in procedure professionalism and efficiency. I don't think that. Could you restate the question as well?
Yes, of course. So my question basically just stemmed from the fact, was the general environment following that testimony adequate? And can you just generally describe the relation at which the faculty felt to that statement as well? And did that, and the process at which the school was able to function after the fact?
So in addition to my previous statement about professionalism and efficiency being impeded after Principal Skinner went over Ms. Portnoy's head, professionalism and efficiency was also impacted by the statement Ms. Portnoy put out. There was a lot of drama, a lot of talk about this statement. It obviously caused a lot of infighting and in conversation between the staff and faculty members who aligned themselves with Principal Skinner's decision and against Principal Skinner's decision. However, in my own personal opinion as a teacher at Silver State Middle School, this wasn't as significant. This change in efficiency wasn't as significant as when Principal Skinner went over the head of Ms. Portnoy in overriding the decision of the math department.
Okay, phenomenal. I'm just going to ask one additional question, if you don't mind. Can you just describe the nature at which the plaintiff exhibited, just following the statement even beforehand? How would you generally describe the professionalism outside of that incident, just one more time?
Like I said before, Ms. Portnoy's professionalism was definitely lacking and could have been improved on. I don't feel like I'm in the best position to comment on Ms. Portnoy's professionalism outside of this because I'm just not in her department. I work within the English department, so I think other staff members might be better equipped to comment on her professional manner.
Okay, and that seats my time, and I yield the rest to the chamber. Thank you, witness, as well.
Point of information to the counselors. They get cross, correct? Okay, Mr. Kung, you now may begin your cross-examination of the witness.
You said you're an English teacher at Silver State, right?
That's correct.
Do you support Principal Skinner's program, or do you not?
I do.
You do. So you think the way he implemented it, the policies he implemented were good?
Yes.
I guess I'm a little confused about why an English teacher would be providing insight into like mathematical, given that like the program was about skill-based grouping. What is the correlation between skill-based grouping of math classes and like the mathematical concepts that would be applied to an English department?
I supported the program because it sought to integrate both the liberal arts departments at Silver State Middle School and the STEM departments. So it wasn't just about changing the skill-based, it wasn't about changing the skill-based grouping methodology at the middle school necessarily. It was more about moving all departments toward a more integrated and more effective curriculum.
Do you think that in this integration, she would have had Ms. Portnoy would have had a like major executive position in this had she been incorporated into the process, given that it's a bridge between like mathematical concepts and all other language departments and all other like subjects?
That is a decision that is completely up to Principal Skinner. I have no idea what Principal Skinner would have decided, but it's most likely that Ms. Portnoy would have stayed as a head of the math department. To clarify, these departments would not have been dissolved. There was just an integration as the goal.
Right, I understand that. I'm just working on this integration. Do you think she would have been, her math experience, like, was it a major part to the point where she would have been given executive position in this integrative process?
Like I said, I have no idea what Principal Skinner's plans were, but I see no reason why Ms. Portnoy's expertise wouldn't have been valuable.
I guess the question I'm asking is, was it a process that would implement other subjects into math, or was it a process that just blended them all together?
The math department wouldn't have been like superseded by other departments. It was more an integration and cooperation. Does that answer your question?
So you would say that they all equally have, like, during this integration process, every department would have an equal part of, like, their integration process.
Of course, it goes without saying that all of these subjects are equally valuable and essential for students to learn. There was never going to be a devaluation of any of these programs, more so an integration and cooperation between them.
Okay, thank you. To your knowledge, given that she wasn't incorporated into the process, what did the process look like for integrating math? Was it just other teachers? What was that process?
I'm sorry, could you restate the question?
Ms. Portnoy was not included into the process of integration. Who from the math department was, or was there no math department at all?
I don't know. I don't know who was involved in the math department integration process. I only know that who was involved in the English department's process of integration, myself.
So you did not have, why did you not have a major role? Was it because that there was just equal integration? Was there a chair board that was like a department exec that represented?
I'm
it?
sorry, you said why did I not have a main role?
Or like why did you not know about the math process? Was it because there was an executive position that had been filled by a department chair that talked to the math department?
I didn't know because it was so early in the process of integration and starting the program up. So we honestly barely had a chance to get the program initial steps off the ground before a lot of the issues between faculty occurred. So that's why I don't know.
You say you started to see unprofessionalism after this implementation. Would you say that there was a major increase in unprofessionalism in the workplace after she made the comment criticizing Mr. Skinner and commenting like pile of garbage and clandestine?
Like I said in my previous statement, could you restate the question actually?
Yes. So you said that in the previous cross-examination of the DA, you said that you started to see unprofessionalism in the workplace after Mr. Skinner implemented the program without consulting Ms. Portnoy. Do you think after Ms. Portnoy went out and criticized Principal Skinner and called her program a pile of garbage and clandestine, would you say there was a major increase of unprofessionalism after that?
Yes. To clarify my earlier statement, I believe the crux of the unprofessionalism started with the interactions between Principal Skinner and Miss Portnoy. I think it started with Principal Skinner going over Miss Portnoy's head, the head of the math department. So that was the initial instance of the unprofessionalism. And then Miss Portnoy's response was to issue this statement to all staff and faculty that the program was a pile of garbage and clandestine.
This would be probably hard to clarify for you, but do you think that there was a more increase in unprofessionalism after Miss Portnoy made that comment, or when Mr. Skinner went over Miss Portnoy's head?
I guess it's, like you said, hard for me to pinpoint the exact moment that professionalism declined. But I think that when an established structure like department heads and like department faculty is overruled by by the principal, for example, that's a massive breakdown of the way that the school board is supposed to work. So I believe that was the real start of the problem.
Point of information really quickly, are we allowed to object previous question?
Can you clarify?
So the opposition just made a non-topical question earlier. Are we allowed to object to that, or?
Can you restate what the non-topical question was?
Yes, so I don't know it verbatim, but it discussed the relevance of the independent departments and their participation in the general process. I believe my opponent steered away from the plaintiff's executive decision-making within the process, which is what we are discussing. So I don't believe that is to be topical at all.
I think it speaks to the relevance of like whether other chair execs were incorporated into the process or not, and how much they were how much other departments were integrated into that process of
Yes, of
integration.
course. But again, of previous question and of previous speech, we've already discussed that she was exempt from the decision-making process. Therefore, that question would not be topical, logically.
I would say that I was.
Point of information, you can object to relevance. You can hear their argument for whether or not the question is relevant. So you can object to relevance.
Okay, phenomenal. So yeah, I would object to relevance then.
I would say that I was trying to.
Objection overruled. That line of questioning provides reasonable context to the role of department heads. So overruled.
Okay, yeah, thank you, just for clarity.
You're welcome. You may continue.
I'm sorry, just to clarify, do you remember the last question that the DA asked about whether or not you could offer comments on the professionalism of Ms. Portnoy?
I'm sorry?
The DA asked you a question about whether you could offer comments. Actually, never mind. It's fine. I would like to talk about the empirical baggage. The only empirical baggage of the process was that previously it did not work, right? Or we had low education rates. Was that correct?
There was no empirical evidence implying that the new program would succeed or not succeed.
Okay. I have no further questions for this witness.
Thank you, Mr. Kung. Plaintiff, do you have another witness you'd like to bring to the stand?
Yes, of course. So I would additionally like to empower a parent who actually attended the open house event and was able to experience firsthand concerning the plaintiff's rhetoric as well.
Point of information, judges, please excuse the witnesses when cross-examination is over.
Point of information. So the questions our questions are going to be after the whole cycle of all the witnesses, correct?
What questions? Your questions?
Yes, our questions.
Oh, for the witnesses? Right now.
Right now. So it's going to be directed at this one witness, and then once we're done, we're going to proceed to the next witness. Is that correct?
Yes.
Okay, thank you.
Okay, never mind. Forget that. Judges, now you may ask your questions towards the witness or the attorneys.
So you are an English teacher in the English department, and you were involved with the adoption of this new system, the integration, correct?
Yes.
So are you the only teacher that was involved in this, in the English department?
I was not the only teacher that was involved. I had another colleague in the English department who specialized in 5th grade teaching, involved in the program process.
Are you the head of the department?
No.
And you don't know of any other involvement of other teachers in other departments?
No.
Okay, thank you.
This question is for the witness. Were you in contact with Mr. Skinner during the development of the CoreLink program?
Yes, Principal Skinner reached out to me directly by email to ask if I would like to be involved in the tentative, a new program tentatively being used at the school, and I said yes.
Okay. Did he ever say anything about specifically excluding Ms. Portnoy from the program or excluding anyone from the program at all?
No, Principal Skinner only asked if I wanted to be involved.
Okay, thank you.
To your knowledge, is Ms. Portnoy the only employee who was skipped in the integration process?
Ms. Portnoy was not skipped. Ms. Portnoy was made aware that the program was going to be, was being considered to be used at the school. Ms. Portnoy, the only time Ms. Portnoy was quote unquote skipped was the decision to tentatively approve the usage of the program on April 30th at the school. April 30th, is that correct?
Question for the witness. Do you know if any other heads of departments were also skipped over? Did Principal Skinner, my question is, did Principal Skinner just go along with his own personal opinion of going through with implementing CoreLink?
Like I said, I don't know, but I'm assuming that my assumption is that if Principal Skinner made the call, which he has the right to do, by the way, to go over the heads of the department heads to tentatively approve the program, then he did it. He most likely made the same action for all other department heads as well.
I have a question for Mr. Albert. Would you say that Principal Skinner was open to input from teachers, teaching heads, and use that input in his decision?
Yes, Principal Skinner, like I said, when he initially reached out to me, he asked if I would like to be involved and continued to seek my input throughout this process of trial and error for the program. And I know that my other colleagues in the English department also continually communicated with Principal Skinner about their opinions on the program and what they liked about it, what they didn't like.
How are you sure that Principal Skinner was tentative with the process? Like, was there a verbal thing he said to you, or was this part of the memo, or what?
What part are you asking? What part are you clarifying whether or not it was tentative?
So you said that he tentatively accepted this to be implemented into your school. You said that multiple times.
Yes.
How do you know it was tentative?
It was not, for something to be officially adopted by the Silver State Middle School, the school board has to approve it. So this was not something that was approved by the school board yet. Only Principal Skinner wanted to trial the program. This was not like an official adoption of the program at Silver State Middle School. This was a trial, tentative approving of the program.
So by tentative, you mean temporary until the school board approved it?
Not temporary. I would say more so a trial run.
Can you elaborate on how this was implemented? Actually, excuse me, never mind. Ignore that thought, thank you.
This question is for the plaintiff, Mr. Abraham. Why do you think this witness is qualified to speak about Ms. Portnoy's situation or the situation in general?
Yes, of course. So this witness works in direct correlation with Ms. Portney, even though they are in separate departments within the faculty. He is a reliable candidate. Also, given the fact that in addition, when we are discussing the CoreLink program, it synthesizes multiple disciplines together. So it is not unreasonable to assume that multiple cross-department interactions could have happened. Moreover, I believe this witness is incredibly competent in detailing the jurisdiction of the program and why it is valid to further prove and reinstate why Ms. Portney was advocating for the common good. So this is just a and a very general candidate who has a robust amount of information concerning the case. So I hope that answered it pretty well.
Thank you.
Thank you.
Am I allowed to answer that?
If you want to.
Okay, I think it's a point of information that the witness testimony said he did not work with Ms. Portnoy and did not have contact with Ms. Portnoy during that process.
Does that mean?
I would like to. Oh,
Me? I didn't write down your exact testimony. Oh, I asked how you knew Ms. Portnoy and if you knew why, or the judge asked you if you knew why she was not incorporated, and you said you did not know, and you did not have contact with her.
Does that mean contact directly with Miss Portnoy during the process of the adoption, like asking, or what?
I think it was contact concerning the integration process.
But there was contact outside of that?
I don't know.
You know, okay.
I would like to briefly object. And again, the witness did testify that all departments were kind of synthesized in the integration process. Although Ms. Portney was inevitably left out, the witness still retained contact. And again, I would just like to reaffirm the Supreme Court's rhetoric as well. The witness did not explicitly say as to whether or not he did not hold contact with Ms. Portney during the process of like the reintegration process, right? Or the process of Ms. Courtney being directly held accountable for her action, but rather he can still hold contact in faculty conversation as well as general development gist. So it is very contextual as to what we speak the contact period to be. And regardless, he is still nonetheless qualified because of his robust intel on the program itself to prove for common good.
I'm just going to clear this up. Witness, did you maintain contact with Ms. Portnoy during this process?
I informally spoke to Ms. Portnoy several times over the course of the tentative approval of this program and Ms. Portnoy's statement or that she sent out to all staff and faculty members. I spoke to Ms. Portnoy in text chains that staff members have. I spoke to her in the break room. I spoke to her as a friend and as a colleague multiple times.
And would that be, did you continue that communication following the passage of, or the tentative approval by principal and then following her outburst at the open house?
Yes.
Thank you.
So am I correct in saying that you supported the incorporation of the policy, but you didn't support Skinner flying it over Ms. Portnoy's head?
Yes.
Okay, thank you.
Do you have any objections to Mr. Skinner's, for lack of a better word, skipping of Ms. Portnoy? Did you confront them or not agree or do some action to not agree with them in that any way?
I never took any action regarding my own personal opinion that it was unwise to not consult Ms. Portnoy before tentatively approving the program, as she was the head of the math department. I didn't take any action, no.
Sorry, this might have been already gone over, but when I'm sorry, sir.
So you are aware that there was an open house at Ms. Portnoy, was that correct?
Mm-hmm. Yes.
Was this specifically for the math department, or was this with all, like a general school open house for all the students to go around and look?
This was a whole school open house that I also attended, and every single other faculty, not every single other faculty member, every single teacher attended.
Did you ever have any encounters with the parents or students that entered Ms. Portnoy's classroom?
No.
Have you heard about the controversy with what she did at the open house?
Yes, I was able to read the documents that Ms. Portnoy handed out after the fact.
Okay. Thank you.
Point of information, is the plaintiff allowed to, or the prosecution allowed to call up a second witness?
I think,
Following this questioning, you will have time to call up your second witness.
Phenomenal. Thank you so much, Chair.
Of course.
Your Honor.
Just to clarify, you are the plaintiff and not the prosecutor because this is a civil case, not a criminal case.
My apologies.
You're
I'm the
good,
plaintiff.
yeah. So this question is for the witness. At the open hall session, after Ms. Portnoy handed out all of her pamphlets and gave her presentation, did you observe anything about the environment of the parents or the faculty immediately after?
I was in my own classroom talking to parents of my students. After the open house was over, generally speaking, I stayed in my own classroom until the open house was over. So, no.
Were you at all when you were were you at all advised by Mr. Skinner to talk about the core link curriculum and the implementation of that?
Yes, actually, Mr. Skinner, Principal Skinner said that I could mention the program and our hopes for it if I would like. So I did talk to a few parents that had questions about it, but I didn't directly bring it up.
Did Mr. Skinner advise you to sing praises of the program at all, or is that completely up to you?
Principal Skinner said that I could answer questions or talk about it in whatever way I deemed necessary to.
Following that line, did Principal Skinner ever, to your information, did he ever contact Ms. Portnoy with that she could talk about CoreLink in any way that she would like?
Yes. He said that he said the same thing to all of us.
Do you share any students with this, with Miss Portnoy?
I'm sorry?
Do you share any of the same students with Miss Portnoy?
Yes.
Are you aware of anything they said regarding Miss Portnoy in the days after not only her demotion, but her open house thing and anything else she did?
No student ever said anything to me about Miss Portnoy being unprofessional or erratic about the program.
Did you overhear any discourse with the students talking to each other?
No.
Okay. Are you aware of any discourse at all with anyone other than a teacher?
No, I'm
Okay.
not aware.
Thank you.
Sorry to clarify that previous question, but there was there discourse amongst teachers after. There's two parts to this question. Was there discourse amongst teachers aside from Ms. Portnoy after Mr. Skinner's decision to move into CoreLink, start pushing CoreLink? And secondly, was there any discontention amongst staff after Ms. Portnoy made her objections known of the CoreLink program?
Yes, to answer the first part of your question, all staff had plenty of opinions that they were happy to voice about the Core League program, and I was able to hear from honestly every single member of staff about their own opinions on it at some point. To answer the second part of your question, honestly, the same can be said. Teachers, I'll just speak to the Silver State Middle School. We're very in touch with each other. It's important to the efficiency of the school that we are in constant contact with each other. So, yes, we talked about it.
Are you aware of the specific conversations that teachers had with each other regarding Ms. Portnoy's decision? Or, sorry, her actions?
I can only speak to the conversations that I had with my own colleagues. Point of information, Ethan, if there is no like actual conversation written down on any of our case materials. Okay, back in character. I had a conversation with a fellow teacher from the English department about our own opinions on the Corling program. This teacher that I did get the chance to speak to, she did not like the integration idea. So we generally just talked about our own opinions. We didn't really talk about Ms. Portnoy's behavior or professionalism or anything like that.
Was the unprofessionalism within the work environment, this was only teachers to teachers, never teachers to students? Or are you not aware of any?
That's a very complicated and loaded question. I would say first of all, I think it's important that we clarify what unprofessionalism means here. Unprofessionalism in a school environment, in my own opinion as a teacher, it looks very different from school to school, but I would ask that that the attorneys at some point attempt to define what professionalism means here and what lack of or impeding effectiveness means in this case as well. As far as, what was the second part of your question?
I'll just rephrase it. Would you ever say that the this affected the interactions with like teachers and students? Like, did teachers ever bring it up, or was there any like changes that happened because of this?
I believe that you asked whether or not students or parents were aware of Ms. Portnoy's quote unquote unprofessionalism. Is that correct?
No.
No?
I was asking whether the unprofessionalism, as to be defined later, influenced or affected the teachers and their interactions with their students.
No. The teachers at Silver State Middle School are very capable of handling emotionally tumultuous situations and not letting it affect their work and interactions with students.
Point of information, am I allowed to very briefly ask the defendant a clarifying question, or
Do you mean witness?
either the witness as well, either or? If they're not letting I'll ask the witness.
It is our time for questions. Your time for questions was earlier, so no.
Okay, that's fine.
Thank you.
Regarding your relationship to Ms. Portnoy, do you have any information as if she had a tendency to not agree with Principal Skinner's leadership or decisions?
I don't know.
Do you know if the relationship between Miss Portnoy and Principal Skinner was strictly professional before this whole thing?
Can you clarify that question?
So, as in there was like no hostilities, there was no like drama that you're aware of?
I don't know.
You don't? Okay. Thank you.
That is it for judges questioning. Mr. Albert, you may now step down. Oh,
Thank you.
Mr. Abraham, you may now bring your second witness to the stand.
Thank you so much. I would like to empower a parent or an individual who attended the open house event and directly saw the speech and oratory given on the behalf of Ms. Portnoy. Would the witness please rise to the pedestal at this time? Phenomenal, thank you. Okay, just another point of information. Will my time begin on my first word?
Yes. Yes.
Okay, phenomenal. So I would just like you to, on the behalf of the committee, just briefly state your affiliation with not only the school, but with Ms. Portnoy, and why you decided to attend the orientation specifically within her classroom.
Miss Portnoy teaches my daughter in her 6th grade class. So I was there to get a report on how that year had been going.
Okay, phenomenal. I would just also like to ask a few logistical questions on Ms. Portnoy's speech and oratory that she gave. Can you quickly describe the booklets that you received on open house and other conversation that you had at that time?
The booklets were pretty simple, plain printer paper typed on a document, very conversational, very much informal. I would say some very spirited language, but very, very passionate. You know, you could feel that, you know, she sat there and she typed this up right from her heart, and I personally was very moved. Her actual speech to us, the other parents in the room, was a little more professional, a little bit more, you know, straight and narrow. She outlined her problems with it, and then she only gave out the booklets when we specifically asked if we could have some more information or if there was something written somewhere. They weren't just kind of passed about. They were specifically on request.
Okay, phenomenal. Just another additional question. What do you think about the logistics of parents being entitled to learn more about the curriculum at hand and at stake?
I mean, I think sixth grade math is probably the foundation of all math. I mean, the stuff I was doing in college was the basics I learned and reinforced in sixth grade. I think it's damn important. I mean, I got another kid year down, gonna be doing the same program next year. I mean, I feel I'm entitled to know the good and the bad. And I'm not a teacher. I'd be an atrocious teacher, but I want to know from someone who's got their hands dirty, been in it, and that's what Miss Portnoy is. And I felt glad to be informed and know a little bit more about it.
Okay, phenomenal. I'm just going to divot the conversation really quickly to the core link curriculum in the program itself. Prior to this interaction, can you just discuss what you knew about it and whether or not you were going to enroll? Just any contextual clues as to what your standpoint was concerning the program.
My standpoint was pretty neutral. I didn't know much about CoreLink. I say it was in a little like booklet they sent to the house. They had the kids bring home. I read through it. I've been planning to do a little bit more research. I'd actually been planning to ask about it at the open house from a couple of my kids' teachers. It's a little dense, a little vague. I had a pretty neutral opinion on it because I don't know what's good teaching wise. So I'd say I was really had a split decision on whether to enroll or to stick with the traditional program before having attended that open house.
Okay, great. How would you describe the initiatives taken to facilitate transparency on the behalf of the school faculty? Do you think it was tangible? Any lingering thoughts that you had about it?
From the school administration?
Yes, transparency on behalf of the school administration concerning any program or anything related to the core link.
I think they were fairly clear on what was happening and the fact we would have a decision, but I don't remember a lot of why I should enroll in CoreLink. I remember reading through it, and there's a lot of how it'd be different and a lot of which option, and I don't quite understand. It was never clear to me, and it frankly still is not clear to me, speaking right now, why CoreLink, the benefits of it. It's vague still to this day.
Okay, and how would you describe Ms. Portney's demeanor in relation to other faculty at the open house or other parents? How would you just describe the general emotional status of Ms. Portney? In relation to other people, I would say, specifically school board.
In relation to the school board?
Not board, like any teachers or individuals that were at the open house, if you saw her having interaction with them.
I will definitely say she had the most passion. It felt like she wanted to be there to talk about it. It felt like she had something to say. She wasn't, checking off a box. Like I felt a couple of the other teachers, they were just kind of running you through the rigmarole of your kid's doing great. They need to do more homework, yada, yada. She had something to say. She was very, very passionate. Her voice filled the whole room. She knew what she wanted to say. She wanted to tell us something.
Yeah, great. How would you just describe the general school climate of the open house? Was it professional outside the Miss Portney incident? Was the school professional? Was it running fine? Was the open house mobile? Just anything related to that logistic?
I'd say logistically, outside of Mrs. Portnoy towing the line of appropriateness, it was as professional as a school could be. I mean, obviously it could be tighter, it could be smoother. I mean, I'd love if teachers could go into, a little more depth on how we could actually help our kids be better, but I suppose that's asking for too much. So I'd say it was about the average, open house you go to every year. Outside of, Mrs. Portnoy, it was, relatively the same.
Okay, I'm going to ask about the components of the booklets you received. So how dense in information would you say it was in the booklet concerning just like the logistics of the core link again, the empirically backed evidence provided on the behalf of traditional systems? How would you, was it like the Constitution? Was it very dense or was it just pretty like straightforward and small?
I say it was decently long, but it was never really complicated. It kind of felt like everything was at the most basic kind of level. It broke it down pretty simple. I want to say it was maybe 10 something pages. I think probably somewhere in the ballpark of 1,000 words or so, give or take. There was a diagram or two, and it was mostly going over the flaws of Core Link, how it was going to cause negative benefits to our students, and the evidence for the system they were already using. And admittedly, there was a little bit of sharp language mixed in. It was definitely not, it was not a school textbook, that's for sure. But it's pretty simple.
Yeah, so just for clarification on the behalf of the committee, do you remember anything verbatim as to what she said or what the booklet said? Because you mentioned strong-spirited language. I would just like the committee to have the specific logistics of that.
One thing she talked about, I remember very clearly, was how clandestine it was. She felt very strongly that the system had not been properly explained to parents, that kind of it was presented as an equal binary. You do A or you do B, and both are kind of even. She kind of felt that was underhanded. I can't quote anything verbatim from the top of my head, but I remember distinctly she felt that it was trying to be slipped under our radar. And I'm tempted to agree, because I feel like the only thing I really know about this program came from this pamphlet and this teacher. She was really upset about the principal, I recall. She felt that he had been kind of leading this, kind of sneaking it in. It had been kind of his prerogative.
Okay, phenomenal. So I'm going to ask an additional question, specifically concerning school board and faculty. So how long would you say you've been involved in this district, and have you interacted with anyone from the school at any point prior to this open house when you decided to enroll your daughter?
Yes, I have a number of children. We've been going to the school. Miss Portnoy actually taught my eldest, who just graduated. So I've definitely been involved in the school for a long time. Probably every aspect of it, all the different sports, all the different, clubs. I mean, you know how middle schoolers are. They want to try it all, and you got to pay for it all. And
yeah, thank you so much. That was very thought-provoking. So an additional question to that, can you just go into a little bit of depth concerning the good and the bad? Any instances where you felt like both of which were accomplished? What were some of the bad experiences that you felt on the behalf of the school previously?
The school over the years has had a consistent problem with being a little cold towards parents. I always kind of felt I was never properly informed on the things going on. And I can't say if that's a school issue or if that's me not being the brightest bulb in the box. But I always kind of felt consistently like I was having to go to these open houses and double check with teachers to figure out what things meant, which kind of sucks. I would love to not have to take time out of my schedule to figure out what the hell is going on. That's irritating. For the good, I do think I've had, it was good and bad, correct? That was the question. I will say I've never had an outright hostile experience, with a teacher. We've had a couple who were indifferent, but, I've never had my kid come home crying. There's always been, I've always felt that they were pretty well taught. They always seemed to know the things they needed to know. So what more could you really ask for?
Yeah, of course. So would you say Ms. Portney contributed to that robust, I guess you can say enterprise, and sequences of knowledge exhibited by your kids? Or
I say 100%. I think she was one of, the best math teachers they had. I feel like she really walked that line between teaching them without overwhelming them. I know for a fact my eldest was able to take AP math classes because she had such a strong foundation. I personally felt that, Miss Portnoy is a big reason why a lot of my kids have been successful.
Great. With that line, you kind of touched upon her passions as an educator. Would you say then that those passions were not only geared to academia, but just generally?
I am so sorry. Time has
Oh, my
come to
apologies.
an
Sorry,
end.
sorry. I would yield my time then.
And I would ask for a point of information. On the bench memo I was given, it says that this trial, or at least the incidents concerning this trial, happened in 2001. Is that still a thing? Because a few testimony has been given about like emails and things like that. How much of that are we still sticking to the 2001 or no? Got it. So what should we use, like 2025 as like a? Okay, thank you.
Also, point of information, when is lunch recess? 1? Okay, thank you. We were wondering.
Thank you, Mr. Abraham. Now,
Thank you.
Mr. Kung, you may move into cross-examination.
I'm doing very well, thank you.
Your mic is off.
You are a parent of the student, correct?
Yes.
And you said your standpoint was pretty neutral, and you didn't really know what the Corling program did, right?
Yes, did not know a ton about it.
And you said you weren't really involved with the school, is that correct?
Weren't really involved in what sense?
Would you say you were involved in the school a lot? I remember your testimony saying that they were very, cold about involving your teachers, informing us.
Yeah, to clarify, I was relatively involved in like school events, extracurriculars. I talk with my teachers that coldness is more kind of official announcements, changes in policy, things like that. So like, interpersonally, I never had a problem with, anyone. It was more just kind of big changes. Always felt they were very stark and not well explained. That's clear.
Okay. And you said that, your kids had done really well in Miss Portnoy's classroom, correct? So would it be a correct statement to say that given that you didn't know too much about this, you deferred to Mrs. Portnoy about the program?
Yes, I think it would be a fair statement to say that I trusted Mrs. Portnoy.
So when she said it was, when she criticized it, you would also have disagreed with the program. And it also, right, is that correct?
Not inherently. I would have had to see what she had to say, which I did. And
Right.
what she had to say convinced me,
Okay.
to be clear.
So just to be clear, Miss Portnoy informed you about her opinions, and then you agreed with her.
Yes, ultimately I agreed with her.
So you thought that the school program implementation was bad.
Yes.
Okay. I want to quote you in earlier. You said the school setting was just fine, correct? I believe the line you used was towing the line, and it was as professional as it could be.
The towing the line, common and professional as it could be, refer to two different things.
After that, you said it was as professional as it could be.
Oh, yes.
It was referring to.
My apologies.
Okay.
I'm getting my two statements confused. Yes, you are correct. Those are, in fact, what I said.
Given that you didn't know, you also said that you didn't really know too much about like official changes, official announcements. Just as from a top level, a broad level, you would say that you didn't see any like miscommunication or any like unrest, right? Because you said it was as professional as it could be, so you would say that you didn't see any like major problems within the teaching community, like the teaching staff.
I did not see any problems in the teaching staff. When I went and saw, they all seemed like the average teacher to me when I showed up at the open house.
Okay. Did you ever, after open house, did you ever go back to the school?
Every day to pick my child up. Do you mean in like a?
When you were hands-on with the actual school?
No, I cannot
No.
say I did
Okay.
after it.
I want to talk about next the packet.
Yes.
You said you had requested additional information, and she gave you the packet.
Yes.
How much of the packet consisted of her criticism against the current school system?
The school system as a whole,
the
or
quarreling program? I apologize.
I would say all of it was either her criticism of it or her defense of the prior program.
Okay.
That was the whole deal.
So, and you said that she was not talking about this program in class. It was more when it was in the packet, correct?
No, she did both. She spoke about it in class, and then when pressed for more, she handed us the packet.
Okay. When she was talking about the program orally, was it also disdain for the program?
Yes. I don't know if I would use the word disdain so much as distrust.
Could you just clarify what you mean by that?
It was more that she thought the program would be a negative, it would not benefit, as opposed to a disliking of it. That is the clarification I'm making.
Okay. So just to be clear, you went to the open house. You went to teach Ms. Portnoy's classroom. She talked about her dislike for the program. When you asked for more information, she gave you a packet that admittedly would probably have been purposed for that night, right?
I am not certain what night it was purposed for. It wasn't dated. Nothing in it indicated it was specifically for parents, but nothing indicated it wasn't.
Do you remember how many, can you give me an estimate of how many packets there were that night?
I want to say she had maybe 2 or 3 dozen just kind of printed out.
Okay. And do you know if every parent had requested for how many parents requested for more information? Was it everyone?
In my room, when there was about, I'd say 9-ish parents, and all of us were at least interested in seeing what the packet had to say.
Okay. So you guys, I'm pretty sure the case summary says 15, but you guys all received the packet, correct?
Yes.
And in that packet was 100% of it was dislike for the program and reasons why it would not work.
Yes.
Okay. So I think I just want to summarize what I've got, the information I've obtained from you. The packet, she was a parent who you deferred to. She was a teacher who you deferred to for your knowledge about the curriculum, correct?
Yes. With 20 years of experience, I felt that she probably knew more about teaching math than I ever would.
Right. And she only ever talked negative about the program, or gave reasons it was negative or reasons it would not work, correct?
Yes, that is correct.
Okay. And you deferred to her because of her 20 years of experience and her, title and your experience with her being a good teacher, correct?
Yes, I felt that all of her qualifications made me believe that if she had something to say and she had evidence to back it up, then I should trust her.
Okay. Point of information, how much time do I have left?
You have 2 minutes and 15 seconds.
Cool. Okay, I apologize. I just want to make this very clear so I have no misinterpretation. Your disdain for the school system that was implemented came from Ms. Portnoy, correct?
Ms. Portnoy and the evidence she showed to me, yes.
What was the evidence she showed to you?
She showed me, first, the empirical evidence showing how the system that had been used worked and the flaws in the system, the live course system, if it were to be implemented.
The previous witness testimony said that the system did not work, and that was, as a school administrator, they said that it was That was the reason that they were implementing, because they have skill-based math classes. That was the reason they were implementing the program. Why does that?
Say he was referring to something else. He was referring to disparities among various minorities, which
is-
this program aimed to combat.
Right.
But what Ms. Portnoy believed is that that would come at the expense of the education of both those minorities and everybody else. And saying, say she did not deny that the aims of the program were good, but I mean, I think Sam Johnson said it best: "Road to hell is paved with good intentions." The idea of a program isn't worth much, and I felt what I saw showed that any of the conceptual benefits wouldn't actually appear, and it would just hurt everybody.
Okay. How much time do I have left?
You have 30 seconds.
Okay. So okay, just to clarify one more time. Your information for disdain for the program came from Mrs. Portnoy. That led you to believe that the program that the school was using was bad, right?
Yes. Mrs. Portnoy
Given
has earned my trust over the past 7 years, and I am inclined to believe that her expertise in teaching math leads me to trust her opinion on subjects related to math.
I'm
That
sorry,
will
what
be
was your
the-
name again?
Huh?
What was your name again?
Kyle Curtis.
Kyle
That will be
Curtis.
the last question.
Thank you, Mr. Kung. The court would like to call a 5-minute recess, so we will reconvene at 12:26. Thank you.
Am I allowed to still keep working?
All right. Recess is now over. We will reconvene the court, starting off with judges' questions. Take it away.
This is a question for both the plaintiff and the defense. How can I please have both of you define public concern?
Would you like to go first, defendant, or? Okay, yeah. So a public concern would be defined as a situation or dilemma that endangers the public, whether momentarily or indefinitely, and provides a genuine risk to stability within various different departments. Public concern could be defined in a myriad of ways. Any institution or organization that serves the public and is at endangerment is indicative of such.
Thank you. And now defense.
I think public concern for us is defined similarly. I think it is defined as whether it is a concern for government, like public affairs such as government, schools, board of education, and whether or not this affects the people of the public.
Okay. This question is for the witness. You characterized Ms. Portnoy's attitude at the open house as less of a dislike of the quarreling program and more of not thinking it was helpful. Is that correct?
Yes.
Okay. Would you say her would you say in the content of the booklet was more attacking people's character and airing out complaints in the manner of a disgruntled employee, or would you say it was more bringing up concerns and offering solutions as if she was a concerned citizen?
That is, good question. I think it was definitely a very personal document. I think, I don't know if I could say, but it definitely feels like she was worried about our kids.
Okay.
You know, you could feel that.
What do you mean by personal document?
She's very passionate about it. She clearly cared about it, you know. I think, you know, if it was, it was something that she herself wrote. It wasn't, you know, purely, you know, a takedown. It was a kind of document that could have only been written by someone with her experience and her life.
And finally, in the booklet, was there any content about the character of other people, including the principal, Mr. Skinner?
Not directly. There was a lot of discussion about how the administration as a whole was handling it, which she felt was very autocratic. It didn't give the people who actually were educators a say. She felt it was very underhanded, that it was not well explained, the actual flaws and what you were giving up to go into this program. It was not specifically aimed at anyone, but it was there was definitely clear that she thought the administration had mishandled the entire program.
Thank you.
Yes.
I'd like to ask the witness, which pamphlet did you read? There were two.
I was not aware there were two. I received the one that was handed to me on May 9th.
At the open house, correct?
Yes, at the open house. That was the document I received and read.
Point of information very quickly, if I can ask Judge, Your Honor, I would say, what other separate document or pamphlet could you be referring to?
I did not get one as well.
This is just on the behalf of both of us.
Yeah, sorry. I'm seeing that there were two stacks. One,
They weren't separate pamphlets. It was just the same copy.
from what I'm reading, there were two stacks. Do you want me to read out what I'm
Yeah,
reading just so I
please.
can, and if I'm wrong, then I'm wrong. The evening of the opening house, this is on bench memo, page 1. The evening of the open house, near the entrance of her classroom, Miss Portnoy placed two stacks of material on a small table underneath a sign reading, "Please take one." One set of materials contained copies of What? I'll just move on. Sorry, I'll go back to the start of the sentence. One set of materials contain copies of a 3-page handout listing the math skills sixth graders were expected to master that are set. Oh, I see. Okay, sorry.
Oh,
So were there only one set of pamphlets or documents then?
There were 2 sets, but only one concerned her core link.
Oh yeah,
Oh, yeah.
one of them was about her curriculum.
Sorry.
Okay.
To clarify, I did receive a document about math problems, skills, what homework was going to be looking like. I just didn't think it was.
Sorry,
relevant.
I misread this.
Yes.
I thought it was 2 separate things about.
I think we can just
Sorry, yeah.
finish that. Yeah. Thank you, Your Honor, though.
This is a question for the witness. So did this rhetoric and pamphlet that was given by Mrs. or by the teacher, did that affect your belief in the public education system and the school?
I would say it just affects my opinion. Is that the question?
Did it affect your overall belief in public
belief.
education?
In public education as a whole, I would say my opinion definitely went down of the school because they implemented this program that now that I'm looking at it, I don't think is good. I wouldn't say my faith in public education or this school is like forever shaken. I wouldn't say I no longer trust them. I just simply think they've mishandled this one program. They say it wasn't as though I had utter confidence in them before. They've mishandled other programs, and sometimes they've done programs really well. So this, say, was another thing that slightly lowered it. In the future, I'm hopeful those are things that will raise it. My opinion is ever changing. So I say my belief is still intact. I still wish to attend this school and keep my kids here, but I'm definitely disappointed in this program and how and why it's been implemented.
This is a question for the witness. Did you meet Mr. Skinner, Principal Skinner, during the before this or during the open house?
I have met him before, yes.
What was your opinion on him? Did he seem already adversarial to Miss Portnoy?
I can't say I ever saw him interact with Miss Portnoy. Every time I met him, he was very buttoned up. I say your typical administrator, nothing unique jumps out to me about him, but I have met him before. He was never adversarial with me, shook my hand, called me Mr. Curtis. The basic respect was there. But I did not have a personal relationship with him, and I never saw him interact with Miss Portnoy, nor did I ever hear her complain about him before May 9th.
When you received Ms. Portnoy's pamphlet, did it maintain professionality to the parents throughout the conference? And can you describe, if any at all, any instances of the contrary to that professionality?
Could you describe what you mean by professionality?
Like, were there any instances of, for example, harsh language or any heated topics?
I would say there was definitely harsh language. I wouldn't call any of it particularly vulgar language. There was nothing in there that made me, go, shouldn't be saying this. I wouldn't say there was, anything particularly in there that made me go, this is inappropriate. The fact the person who wrote and handed this out is teaching my kid makes me upset. I do think the language was harsher than maybe the traditional professional standard, but I also think the traditional professional standard got me a program I didn't understand and a choice I wasn't clear on, and this made it very clear what my actual options were. And I personally felt it was if it had been given to my children, I would be bright red, steam coming out of the ears. But as it stands, I think it was less professional than perhaps the standard is, but it was what was needed for the situation.
Thank you.
So, you received a pamphlet in the open house in the classroom, correct?
Yes.
So, where would you say the pamphlet was prior to her giving out the pamphlet to the parents?
Just sitting out on the desk.
Was it on a desk where the parents could see it
Yes.
easily?
Yes. It was on a desk where anyone could have seen it had they walked in the room.
Was it like near the doorway?
Yeah, it was around, not the doorway, but kind of on a central table, like right around where she was talking. It was, you could not have missed it. You could see there was a paper on the table.
Sorry, okay, so you saw that there was a paper on the table. What was I gonna say? Would you say that? Sorry. So did you see any students there at the open house?
At the open house, a couple from the local high school, Silver State High, were kind of acting as guides, showing some of the newer parents where they could find the classroom, but none of the 6th, 7th, or 8th graders.
So there was a previous testimony from our English teacher. He said that there were roughly 15 students in the classroom. Can you describe what those students looked like? Or just describe them?
In Miss Portnoy's classroom?
Yes. Am I wrong for interpreting that? Or
Point of quick clarity, I believe he's referring to the open house.
yes.
I also think it was 15 parents.
It was, just for clarity, it was 8 to 9 parents, and around, I would say 15 students, and the witness could allude to that.
Yeah. So can you please explain the demographic of the students that you saw in the classroom?
Yeah. I mean, I can do it. I'm good at improv, but no, yeah. They were. I said the document I read said there were not any students in the classroom. But
I don't think we can call an impeachment right now, but
no.
that's up
So
to
how
the
should I
justice.
operate as under what I read or what they were speaking? Yeah. I see.
Okay.
I remember by your average kid. I mean, I couldn't tell you the difference between one 6th grader and another unless they're mine. So
Just kids, correct? Like they were just a kid?
What?
Like
6th graders, I'd
okay,
say.
okay.
A couple of them were probably 5th graders, maybe older. I did not recognize any of them.
Did you see any of the kids grab the pamphlet?
No,
Were you aware of any parents that grabbed the pamphlet beforehand?
not that I saw.
Did you ever see the kids being alongside their parents and being in the room with a discussion about the pamphlet, or in general about the core link?
Yes, there were children in the room for the discussion about the core link.
And they were approximately middle school age?
More or less, I would say.
Okay, thank you.
So during the open house, Ms. Portnoy did not announce the existence of the booklet, but instead referred specific parents who asked, correct?
Yes.
Do you know about how many parents asked and then took a booklet?
Only one parent asked and said anyone who wants more information can take a booklet, and at the very least, all the parents in the room took one.
Okay. Did you hear of any discussion amongst the parents or any, like generally what was the environment of the parents?
It was very, so I don't know if anyone in this room has children, but when you read something and you don't want them to know, so it's kind of that suppression of, so it's kind of hard to read what the parents kind of felt because there was kind of a putting on the calm, everything is normal face. I was doing that myself, kind of put on that mask of, yep, I'm just reading another document regardless of how they felt. It was a very kind of tense, kind of muted feeling.
In general, did the parents seem angry or dismayed or any other emotions?
In the room, they all seemed, like I said, very like, that tension. You don't want the kid to know something's wrong. That there's papers saying bad things are happening, especially at that age. But afterwards, a lot of them were very distressed to have heard this. I know a couple of them who had opted into the live course system were upset at that decision. I do know a handful of them were not pleased with the way Ms. Portnoy acted. I know a good chunk of them were pleased to have heard this information. So there was not a consensus in the room. Everyone had their own take on it.
So you would say it was divided then?
Yeah,
The response was divided.
It was divided.
Okay, thank you.
Yes.
Another definition for the attorneys. Please, each of you, please define what professional means for Ms. Portnoy's or any other person's actions.
Of course. So professionalism, per the court ruling or per the logistics of the case, it refers to the steadfast commitment to instate adequate worker behaviors and mannerisms and demeanors as well. Professionalism in this case and context referred to the internal interactions between faculty members, as that within itself was the only time that professionalism has been tangibly at stake, as according to witness one. So that would be the definition of professionalism.
I think the universal definition of professionalism, I actually just looked it up, was the strict adherence to the skill, competence, ethics, and polite behavior expected from a trained person in a workplace. In accordance to this case, I think it means that they had acted in a way that they were obligated to do, and the polite behavior that would have came with that obligation.
This is a question for the witness. Did you see any impact on your students' academic performance following the change in curriculum?
Point of information, there was, it's a 9-day period for the implementation and the open house night.
Yeah, so giving specific dates, the program was ratified on April 30th and orientation occurred within June. So the interval of time between, for example, summer vacation would have...
May though, right? May 9th? It was May 9th. It was implemented on April 30th and then open night was May 9th.
Thank you for clarification. I read that incorrectly originally. Thank you.
Is he going to answer? Or did you? Oh, okay. Thank you.
So
So, do you have something to say, witness?
I was just going to reiterate what they said. The program had not been implemented.
Okay.
So
So, how would you describe your interactions with other parents at the school? Just in general. You can include before this, during this, and after this.
I found it frustrating. A lot of parents put their kid in school because the law says you have to put your kid in school. And a lot of them don't really, care. They show up to open house night because, they have refreshments. They got cookies and water and whatnot. So that can be very, very frustrating. I mean, that's definitely give me a somewhat negative opinion of the other parents. There are definitely some good ones. I've made some good friends with some of my kids' friends, moms and dads and whatnot. I say as a whole, the parents who were in this specific room when this happened, most of them were pretty checked in. They seem to care about their kids, which should be the bare minimum, but not the world that Silver State Middle School is in.
You said you had a couple good friends with the parents, is that correct?
Yes.
What was their opinion, if they had one, of the institution of this, or the proposed institution of this?
I say as a whole, I think they were in a very similar boat to me before we had talked to Ms. Portnoy, before we had gone in this. They did not know a ton about the program. They didn't think it was particularly well explained. They also didn't think it was particularly relevant. They thought it was the things that schools do where they'll change one name or split a program because it makes it look like they're doing busy work. They kind of felt that way. They felt it was kind of an inconsequential change. Those that kind of saw what happened with Miss Portnoy, so they all kind of definitely agreed that it was a very significant change. As a whole, they kind of fell in the same boat as me. They don't like this new program. They think it's going to kind of screw their kids over. So especially some of them have kids who are high achievers. They think they're going to kind of be set behind, which upsets them. I know that's not unanimous. I know some of them do like this new system. But definitely after talking to Ms. Portnoy, they were all in agreement. This is a kind of major thing. It's not a minor, which class are you going to take? Are you going to do, honors math or basic math? It was a big decision. That was kind of unanimously we all understood that after Ms. Portnoy.
As a parent, how would you describe or how would you predict how your kid and other kids could get affected by this change? Please go in depth.
I think the worry I have is that if it's not sorted by ability, you're inevitably going to have to teach to the median or the bottom of the room. Versus if it's sorted by ability, they can get the education they need. I mean, my eldest, was a bright girl. So I'm glad she was able to be in a class with other people who were somewhat similar, so she could be being taught new things. As Ms. Portnoy kind of illustrated, if it was, not split by ability, we'd run into that fact that, she would have been in a class that was teaching things she already kind of understood. That was the kind of main takeaway I had from Ms. Portnoy. She had more, obviously, and I definitely agree with that. It makes a lot of sense to me, and it's not something I understood beforehand.
How severe do you think this change will affect the higher achievers in the school?
So I'm not, Nostradamus,
Objection calls for speculation. I don't think he is, educated enough to answer that question.
Point of information, can you please repeat the question at hand? Okay.
I'll redact the question if it's.
Objections sustained, yeah. Speculation.
Also, can they object to judge? I'm not too sure on that. I mean, I think I agree with it, but I'm not too sure if they can. Okay. Yeah, the concern is valid. I'll redact the question.
Thank you.
Thank you, Mr. Sorry, what's your name again?
Curtis.
Thank you, Mr. Curtis. You may step down.
Yes, thank you, Your Honors.
Thank you, plaintiff. Do you have any more witnesses or no?
That would be all.
That will be all. Okay.
Point of information, lunch is at 1 and it's 12:50.
Point of information, lunch is at 1:30 now.
Okay.
Thank you.
Can we?
Mr. Kung, you may now begin your witness circuit.
Defense calls James Taylor, Robin Hill to the stand.
You may begin.
How are you doing today, Mr. Hill?
I'm doing quite well, thank you very much.
You are a parent witness on opening night for Miss Portnoy's classroom, correct?
Yes, I am a parent for Jerry Hill in Mrs. Portnoy's class.
Okay. Did you also grab a pamphlet when presented with the opportunity to do so?
Yes, I did grab a pamphlet.
Is it also correct that she, along with the pamphlet, she gave a speech, a oral speech about her dislike for the program?
Well, it wasn't a direct speech on a direct disdain. It was hinted at disdainment.
But then in the packet, it was a direct disdain, right?
Correct. There was there was inappropriate language, I would say.
Okay. What was the inappropriate language you thought was inappropriate?
One of the more inappropriate language that was used was describing the quarterly program as a pile of garbage. I feel like that provided a shock towards me and quite a bit of concern as well.
Motion to impeach a witness. So the witness himself mentioned that Ms. Portney had referred to the program as a pile of garbage. That was, I believe, solely directed to the faculty only. I don't think it was included within the booklet that they received.
The booklet did include the memo sent to all the faculty and staff, so that would have been in there.
My apologies.
Just make sure to double check the memo, please.
Portnoy's packet printed on the letterhead bearing the school name and her official department chair title contained criticisms of Principal Skinner, correct? Did the packet have criticisms of Principal Skinner?
Yes, there were some criticisms on Principal Skinner.
Did he directly? What did she say about him?
To my recent memory, I remember something similar to him being called a tyrant, where he was using a lot of his own powers unjustly.
So, just to be clear, one of the criticisms was that Ms. Portnoy called Principal Skinner a tyrant.
Something similar to that. I do not have the direct memories of the exact wording, but something similar, yes.
Okay. Do you?
I will say it is autocratic is what the term she used is.
Yes, I believe that was the correct term, autocratic.
Okay. In her verbal speech about, do you support, given that, do you have a lot of experience with the school procedures and official programs, so quarreling programs, for example?
No, I would say I am a unfamiliarized parent with the overall education. I have 2 sons, and right now the eldest one is in 6th grade. Sorry.
So was the only information you got about the program came from Miss Portnoy, correct?
I would like to object upon the logistics of that questioning. I do believe that, I don't know the exact term for it, but it was not like a direct questioning session. It was
I'll
trying to fetch
rephrase.
a similar answer.
Where did you learn most of your knowledge about the quarterling program from?
The information about the quarterling program was mainly given throughout the pamphlet, I would say, or the behind the scenes of it. I would say within the school's monthly email, there was mentions on the quarterling being on a trial run. However, it wasn't specifically mentioned on how that program got processed through.
So did you learn the specifics in the pamphlet and from her oral presentation?
Yes.
Do you agree with the program or not?
I have mixed feelings on the program. I'm not still familiar with the overall educational benefits of the program.
Was it pretty clear that Miss Portnoy holistically objected to the program?
Yes, it was very clear from the pamphlet that she had clear objections to the program.
Given that you just said the only information you got about the program was mainly from Miss Portnoy's oral presentation and from the packet, and all of them were negative, why are there some mixed feelings about possible positives with the program?
I believe as a parent, I should hear both sides. And then with the teachers, I'm not too sure on her credentials. I do know she had worked in the math department for 20 years. However, after seeing the unprofessionalism from the pamphlet, I was having a bit of doubts within the
So
school
the
district.
unprofessionalism from the program, from the pamphlet, made you doubt the belief in the school system?
More towards the wording or the quarterly program, and I wasn't too sure on if it was truly negative or it was more of an emotional outburst.
Would you say that the Corling program, would you be open to the trial run presented, or would you want it abolished?
I would be open to the trial run of the quarterly program. I didn't see any negative downsides from the start, so.
I'm sorry, could you restate your answer to the question one question ago? The previous, not the previous question, but the one before that.
Was that question? Sorry. Could you restate that question? Sorry, I forgot. That as well.
It was about how your knowledge came from, holistically came from Miss Portnoy, and why you had mixed feelings given that the only information you ever received was negative.
Oh, yes. So just the unprofessionalism that came from the pamphlet made me doubt her own words. So I decided to have some mixed feelings on whether or not the quarterly program was truly a vulgar or unprofessional or useless program.
So the unprofessionalism made you doubt. Just to clarify, the unprofessionalism made you doubt the program.
Or made me doubt whether the statement of the quarterly program being bad per se.
So the statement of her program being bad, means you had doubt about whether or not her analysis of the program was true.
Yes, that would be correct.
Given that you had doubt, did you take any further action to learn about the program?
I did try my best possible research with the program, but I couldn't get too much detail.
So, I'm sorry, I want to go back to the previous one again. So you said you had doubt about whether the analysis of the program was true, which means you doubted Miss Portnoy based on her own words. Is that correct?
Correct. I felt the unprofessionalism led to some doubts being created.
How much time do I have left?
Time is 42 seconds.
It's okay. I'll just do the rest of my time.
Okay, Mr. Abraham, would you like to be, or you may begin cross-examination.
Yes, phenomenal. So we are first going to go with some clarifying questions, then we are going to go into your witness testimony, and then some other questions on the side if you don't mind. The first initial question that I have to ask is the logistics of the booklets. So did they contain any inappropriate material that would undermine the school's ability to conduct academic stability? Although she did use vulgar language, did anything mentioned within the booklet would hinder the progression of the school from doing its job at teaching your kids?
Could you provide an example of what would you mean by that?
Yes, of course. So let's say she said something in the booklet that would basically ruin the school and would insinuate discourse in the school. Did she do anything of that sort? Or was it just unprofessional behavior?
To my knowledge, it was just unprofessional behavior. She didn't say anything that was clearly factually wrong, but she did use inappropriate language to my knowledge.
Okay. I also am going to ask about, again, the logistics of the open house. Alluding to a previous witness testimony, would you also affirm that the open house, generally for the most part, was very sustainable and professional?
For the most part, yes, but I would like to affirm that the teacher, while Miss Portney, while not directly telling the parents to receive the pamphlet. She provided high recommendations or verbal recommendations to receive the pamphlet.
Okay, so it wasn't by force at all. Moreover, I would just like to ask about her oral speech that she gave. Can you expand a little bit about the logistics of the oral speech?
Yeah, so first I'll go with the forced question. Nothing was forced upon. All the parents could have chosen to receive or not receive the pamphlet.
Okay.
And then could you repeat the second question?
The second question, I believe, was it the stability of the school? Pretty sure.
Okay, so
Yeah, so for the open house, was the open house generally for the most part professional?
yes, when I went to other teachers as well, they also held high professionalism there as well.
And you also mentioned the logistics of her speech. Moreover, you said that she discussed that the school leader was autocratic or a tyrant of some sort. What is your personal opinions concerning that statement? And do you also additionally believe that it was unprofessional?
Since this is my first year having my own child at Silver State High School, I'm not too familiar with the principal's state or position. However, I believe having that as a starting perspective on the principal makes a negative feeling or just a general sense of unprofessionalism.
And you are also a first year, correct?
I am a parent for,
Parent of a first year.
yes.
Okay. And you also said you were unfamiliar.
Sorry, just for future reference, witness, it's middle school, not high school. Okay.
Yeah, no, like sixth grade, their
Yeah,
first
okay.
year and
Just make
entering
sure,
the
just
middle
make
school.
sure.
Yes.
Thank you.
Okay, and you also said that you remained unfamiliarized with the criteria and construct of the program at hand. Do you feel like you were entitled to transparency on the behalf of the school board?
I believe, uh, yeah, I believe if they're gonna implement a trial run that includes my son, then most likely having some amounts of transparency would be beneficial.
Okay, and in the event that this program was not beneficial and instead impeded the ability of your kids to succeed in academic environments, would that then justify the decision-making of a teacher to directly testify against it?
I would rather say no because the teacher made the comments before the results of the trial run. If it was after, I would believe that would be more justified. But since the trial one wasn't concluded, I would say that is unjustified with her statements.
So if the trial run is concluded and the negative consequences incur, the teacher has an obligation to step in then, right?
Yes, I believe then the teacher would have some justification to make those
Let-
kinds of statement with a sense of professionalism.
So hypothetically, if a teacher is really well versed in academia and like-minded programs, and they kind of foretold the events of that situation, do you think they would have an obligation if they knew that it was damaging from the get-go?
I would say they would. It's hard to justify what knowing would mean.
Objection. How you can't say they knew it from the get-go if it never happened.
It's a hypothetical question.
Would you like to object on speculation?
Yes.
Can you repeat the question, please?
Yes, of course. So let's say hypothetically a teacher was very well versed in academia and programs, and they were able to kind of foretell the results of a program given their experience. Would they have an obligation to step in if they know that results are most likely to occur that are bad?
Objection sustained. Speculation.
So
Please either rephrase the question to not be speculative or move on to a different line of questioning entirely. Thank you.
yes, of course. Okay. I'm just going to rephrase the question. So a teacher has a lot of experience in academia and programs, and they might have known that most likely, based on that experience or their experience, that negative results would happen. Would they have an obligation to step in then? Based on their experience, they would think that the program wouldn't be beneficial.
In my personal opinion, I would say, while even though they have high amounts of experience, they cannot fully confirm these, the facts or the results of the trial run.
Mhm.
So it would still be somewhat unjustificational. I would say if they said if they provided a prediction of what could possibly happen, then that'd be more justified rather than making direct statements.
And you believe Ms. Portney did not provide a prediction at all? She just hammered in on the program being bad, ultimately.
Yes.
Okay, phenomenal. Okay. Can you get into a little bit more logistics of the negative comment that Ms. Portney made in the memo? So you received the memo where she called the program hot garbage, correct?
Yes, I received that pamphlet.
So was that a personal attack on any faculty or academic member on the board, or was it just directed to the program itself?
While the comment pile of garbage was directed towards the program, there were additional comments with the autocracy towards Principal Skinner. I do not specifically remember if any other attacks were made to different staff members.
Okay,
however.
so the only attacks on the behalf of staff members that you recall are autocratic comments of tyranny toward the principal, correct?
I believe there were other messages, but that was the one that made.
That was the one you can confirm.
That was the one that was most memorable. Yes.
Okay, phenomenal. Okay. And just for clarity again, you were not made aware of the quarreling program whatsoever until you got to the open house, correct?
There were some messages of the quarreling program
Mhm.
with the monthly email,
Mhm.
but nothing too in depth.
Okay, and were you able to have a personal conversation with the principal prior to the open house period?
No, I did not.
Okay. Did you ever have any interactions with the principal from April 30th to May 9th?
Not within those dates, no.
Okay, and did you have any interaction with the principal at all?
Maybe with the entering of the school with my son, but nothing more from there.
Okay. And one final question, and then I'll yield my time back to the court. And do you believe, based on what your experiences with Ms. Portney, despite being very, very small, that she is a spirited person and she cares on the behalf of students?
I believe she was very passionate with what she wanted to say.
Aside from her mean language, do you think she cares about the students?
I believe her best interest was. Well, I can't fully say with. I'm not fully sure with her overall intent with the pamphlet. But I would say there were some means to provide the best benefits towards the students.
Okay. Okay, phenomenal. Okay, one more question, one additional question, if you guys don't mind. So you had mentioned that you received a memo from the orientation concerning the pile of hot garbage with reference to the program. Did this memo solely reflect her personal opinions about the case, or was it also factually driven? And did you see anything empirical in the pamphlets as well, or was it just opinion based?
It was a mix of factual evidence with how the program was ran by. However, it didn't provide much justification using that factual evidence to support her opinions.
Okay, expand a little bit more, and then that would be my final question. So can you touch upon?
Yeah, sure. While it did show that the program had a interdisciplinary approach towards the math and liberal arts section of learning, it didn't provide much justification on why that is particularly bad.
Okay. Phenomenal. That would be my last question.
Thank you, Mr. Abraham. Point of information from the counselors. Would you like me to call our lunch recess 5 minutes before 1:30 so we have time to get there? Or do you just want it called at 1:30? Okay, thank you. Thank you, Mr. Hill. We will now begin judges' questions.
Point of information, or I just had a question. When are we officially supposed to be leaving?
For lunch or total?
Total.
Counselors?
I believe around 4.
When are we leaving, approximately? For like. Thank you.
Thank you.
All right. Witness. So how would you say your relationship with other parents are at the school?
I would say it's not the best amount of relations. Since this is my student recently got into the school, and my other son goes to a different school, Golden Stage, I would say I don't have the best familiarities with all the parents.
How long have you been in the community of the school?
I've been around this community for around 2 years, with the first year trying to learn about the school before actually having my son attend the school.
Okay. Have you heard any discourse with other parents about this?
No, but I am not too familiar with other parents that's attending this school.
You went to the open house, correct?
I did attend the open house, yes.
Did you have your kids with you?
No, my kids were at home.
Okay. Did you see other kids at the open house? At that room?
I did see other students attend the program, but I do not explicitly remember who or what they specifically did.
Okay. Could you also describe the location of the pamphlets in the room?
Yeah, so to my memory, they were near the corner of the room, and then as part of her presentation or directions, she did explicitly mention that she highly recommends each parent receive a pamphlet before leaving.
Thank you.
This is a question for the witness. You mentioned the inappropriate language in the booklet, and you specifically said the inappropriate language in question was, for example, a pile of garbage, correct?
Yes.
Why do you consider that inappropriate? Is it because of the inherent value, the inherent meaning of the words, or is it because it was the manner in context in which they were used?
I'd say just in general, like both, where the words were, if you're trying to describe the faultiness of a program, you would use a different word rather than something like garbage.
Okay.
And then again, with the general term, a pile of garbage, nothing really should be said. Nothing should be called a pile of garbage in that scenario, in my opinion.
All right, thank you.
Going off of that, did you, of course, the pile of garbage, you feel that it is not appropriate. Did you feel that any other, just the general position of Miss Portnoy during the pamphlet, was that inappropriate in your opinion?
I believe her position did make it a bit less professional. I know she had experience for 20 years, and then her Mrs. Portney using that inappropriate language made me question her credentials.
You had mentioned that you have another child in another school. Are you familiar with their education system? Is it the same as CoreLink or the previous program before that?
No, they do a different system of education. They do not use CoreLink nor the skill-based group. It's something similar to the skill-based grouping, but not like the CoreLink, no.
Is your child in that successful?
While I'm not fully sure on if they're successful, I will say they are doing quite well, and I don't see any negativities with that.
Do you think that if the CoreLink curriculum, for lack of a better word, would be implemented with them, that they would be able to succeed further?
I believe I cannot say this for sure, no.
Thank you.
Point of information. So in the memo, there is a mention of Portnoy sending letters to the editor of the local newspaper. Would we have to introduce that as evidence first to ask the witness? Because I wanted to ask if they heard about this in the community since they've been here for 2 years. Am I allowed to ask about the portion in the memo where it says Portnoy wrote several letters that were published in the newspaper? Because they haven't introduced it as evidence yet, but I'm asking the witness to see if, since they're in the community, they saw it. Okay, thank you. What's your name?
Robin Hill.
Robin. Oh yeah. Mr. Hill. Have you seen this newspaper in the community that you just mentioned? The one that had specifically what I see right here, letters criticizing the proposal?
I believe I've seen those newspapers around, but I have not explicitly read those newspapers, no.
Okay. And okay, thank you.
This is a question for both the plaintiff and the defendant. In Portnoy's memo to the faculty and staff, she uses the word autocratic to describe Skinner's actions. Can you define those terms for me and how you interpreted it?
Just for context, Your Honor, only the word autocratic, correct?
I'm sorry?
Is it only the word autocratic that we are defining?
Yes.
Okay. Autocratic, I believe the objective definition is to be tyrant in nature, and reduce ambiguity and reduce the executive power of people and subordinates as well. And I believe that to be the authentic definition, and as well as within this context.
How does it apply to this situation, in your opinion?
In my personal opinion, I believe that autocratic ideals were exemplified by the principal, given the fact that despite Ms. Prontney's seniority and experience within the field, she was seemingly exempted from a very powerful executive decision-making process. To me, and denotatively, because we are going by the definition, that aligns very strongly with what a tyrant or an autocratic administrator exhibits, right? And I don't see how any lines of scrutiny would be established from that.
Thank you. The same questions for the defendant. How would you define the term autocratic, and how do you think it applies in this situation?
I would define autocratic as a person, system, or leadership that possesses absolute power and demands complete obedience. I guess in the context of this case, it is determining whether Mr. Skinner, whether he is an autocrat or not. I personally don't believe he did, because there were other department chairs that were aligned with this, were integrated into this program.
Thank you.
So, you moved here 2 years ago. That's what I'm understanding from you saying you have been in this community for 2 years. Is that correct?
Around that timeline, yes.
So how was your previous community before you moved here?
I would say the previous community were still, it was alright, I would say. I wouldn't say like particularly good, but they didn't do anything special.
Do you know how long you were in that previous community?
On that community, I've had my eldest son there when he was in 2nd grade.
So approximately 4 years, or sorry, 2, in that other community.
Around that timeline, yes.
Did you know the parents there well?
Not necessarily, no.
Is it the same level of understanding you have here?
Yeah, currently.
Okay. Okay, thank you.
In the pamphlet and speech Mrs. Portnoy gave to the parents, did she say anything that discredited Mr. Skinner's specifically that you can say, or generally if you have that too?
Once again, the hateful, just the spiteful nature of those comments that Ms. Portney portrayed in the pamphlet did try to in my opinion, discredit the overall credentials of Mr. Skinner.
I have a question for both attorneys. It is correct that the defendant was the plaintiff was strictly prosecuted strictly demoted by the school due to her actions during the open house and not her actions before that period, correct?
Yes, and that will be brought up during the rebuttal. Would you like me to expand a little bit upon that?
If you will bring it up later, I will let you bring that up when you
Okay, yeah,
want
phenomenal.
to.
Thank you, Your
Awesome.
Sorry, what was the question one more time?
The plaintiff was strictly reprimanded due to her actions during the open house and not during the before that period.
Yes, we think that the demotion was justified because of her actions during open house and following that when she distributed the memo to the public.
Okay, awesome. Thank you so much.
To clarify, you said So this is based on mainly the open house, but other pieces of evidence that can contribute to this are stuff that happened afterward. As for
Point of information, is this a question for both of us or specifically?
just for him.
Okay, my apologies. I didn't hear.
I think I don't think they have to delineate between like which one is my main piece of evidence.
Or
It
I-
can be like evidence that, if the article was published in the newspaper, the public disdain of like calling it a pile of garbage, I think that can also be like compelling evidence as to why publicly saying that is grounds for demotion.
I was talking about like the main point of the conviction, but I think that works out. So
Okay.
yeah, thank you. Have you observed any negative effects afterward at all?
By negative effects of what exactly?
From the result of the open house and anything else that Mrs. Portnoy or Miss Portnoy may have done.
Okay, so wait, just to clarify, are you asking, were there any negative effects of her actions
Yes.
during open house?
Open house and anything else she did.
Well, I can't give a direct answer. I believe there were some changes in the atmosphere with just the overall atmosphere within the school. I feel like there's definitely much more negative emotions going around. I could tell there was a lot more dramatic where there's it can be clearly inferred that the Miss Portney, sorry, had other concerns rather than had other higher concerns rather than directly just only teaching the students during the class.
Thank you.
Did Miss Portnoy's pamphlet and speech demonstrate more concern for students' overall well-being and success with the new program, or more of, for lack of a better word, bad talking the core link program and Principal Skinner?
In my personal opinion, I believe her intentions were for the best of the students. However, her wordings got the better of her overall message within the pamphlet.
Thank you.
I'll ask another question by a similar question. In the school, you said that there was the atmosphere changed after, correct?
Yes, I believe so.
So, in the town, is this the only middle school in the town?
No, there are other middle schools, but this was the one that was recommended towards me.
Right. Did you see, in your community in general, did you see any adverse effects after Miss Portnoy had this open house? Did you find any adverse effects in the community?
I believe there was a lot more gossip going around within the community, but there wasn't any direct I guess the general spread of gossip was the negativity around the community.
Can I ask another follow-up question to that?
Yes.
How the scale of this, was it just did you hear about situation, or was it more of a, did people have you had, or did you know of anyone else who had, not full-on conversations, but like, I guess full-on conversations around Miss Portnoy's open house or things, newspapers, anything like that?
Well, I'm not sure on the overall news. Well, I would say people started having took more attention towards her wording and use of language.
Okay, thank you.
All right, one final question. I'll make it short. So you said you came here. Is that because of the appeal of the school, correct?
Yes.
Was this because it's like a magnet school, or like the curriculum before?
It wasn't particularly a magnet school, but I believe it was just recommended to me from my previous community.
Do you know why?
Just the overall. Well, they said their student went there and they did pretty well afterwards.
Oh, okay. Thank you.
Thank you, Mr. Hill. You may now step down. The court will call a lunch recess starting at 1:27, and we will reconvene after lunch.
Sorry, guys. Everything we just said was live. That's why you're like. Someone call it.
The court is reconvening on the case of Silver State School versus Portnoy, or Silver State School District versus Portnoy. We will be moving on to Mr. Kung's second witness. Please bring your second witness to the stand. Thank you.
Defense calls James Taylor to the stand. How are you doing this afternoon, Mr. J. Taylor? Could you state your occupation? You gotta turn your mic on.
Sure, I work at the Silver State School Board.
In the Silver State School Board, did you see the memo that was passed out or that was sent around by Mrs. Portnoy?
Yes, I did.
What did the memo say?
Well, there was a memo. As I understand, there was some kind of argument about a core link curriculum that we were doing. And Ms. Portnoy sent a memo out just talking about her thoughts on that core link proposal. She said a number of things that were pretty unkind to Mr. Skinner, the principal.
Could you specify what those were?
Yes. Among a few things, she called it a garbage proposal. She said it was clandestine, which was not true because we had done a number of public meetings discussing this proposal.
Did he say anything? Did Mrs. Portnoy say anything about Mr. Skinner's character?
I don't know if she said anything specifically about his character, but I think the implication that by calling this proposal garbage and just kind of the negative feelings she had about Mr. Skinner, that was an implication of what she said.
Okay. So you just stated that you did get the memo, correct?
I did get the memo.
The memo was then published to a local newspaper. Did you see it in the local newspaper?
I did see it in the local newspaper.
Was it a public newspaper that you think that was I guess popular in this district?
Oh, yes. It caused quite the outrage in our community.
Why did it cause such an outrage?
Well, this was a controversial proposal because of that article she published. There wasn't a lot of negative support for it when we first proposed it, but she rallied a bunch of people behind the idea that this new core link system would be a bad thing.
Quick point of information, if you guys don't mind me asking, on similar lines of clarity mentioned before. It was mentioned that the memo was published in a newspaper. Did I hear that correctly?
Yes, I think that's on the appellant district brief.
So, I'm reading this right now, and it says there's one memo that was sent. There was, yes.
It says at the time Portnoy distributed the offending memo to the public, she had already expressed her disapproval for the curriculum change to her coworkers and principal directly.
Yeah.
And to the public.
I see that there's also one for specifically the faculty and staff.
I think the implication is that it was first given to the faculty and staff and then published to the public.
What I'm reading is that the pile of garbage proposal was not specifically sent to the thing. It says Portnoy, in addition, wrote several letters to the editor of a local newspaper to criticize the core link proposal. One of which the paper published. I don't.
My apologies. Moreover, I would like to, if the court or the honor would give me the authority to do so, I call to object that line of questioning as well as impeach the witness for complying for said line of incorrect questioning.
Can you
Yeah, so I motion to obstruct that line of questioning as well as impeach the witness for complying with said.
The only question I asked is if it was a popular newspaper and whether or not he had seen it in the newspaper. I was moving on to my next question about how it was if he saw it, and then, no, I think you objected to the fact that
you mentioned that the memo was published in the newspaper, but there's nothing indicating such.
It says, at the time, Portnoy distributed the offending memo to the public. That is on page 9.
It wasn't mentioned in the specific newspaper then, correct?
No, it was in the
your claim
newspaper.
that
That was to the public.
So was the memo in the news? Sorry, my apologies.
I'm sorry. A point of clarification. Where are you? What document are you guys looking at to find that any part of this was put into the newspaper?
Says the bench memo from the Word document.
There's not 9.
I'm looking.
There's not 9 pages of.
I'm looking at the district brief on page 9.
District brief. Thank you.
I think it's possible that it's left vague on purpose. We could always ask.
I will concede that it was not in the memo. It was not in a newspaper, but it was made public.
Okay. With that being said, the witness nonetheless still complied with said poor line of questioning.
I think the fact that.
Sorry. So do I have the authority to call for impeachment of witness?
So, I would like to, number one, address Mr. Kung, to rephrase that as the memo was not published. You can say the information was, or the speech that she published something, but not the memo specifically. And for your point, you may impeach the witness, but impeaching a witness is less of a process of, you can't kick him off the stand. It's more just calling their credibility into question. So he will still be up here, but you are just calling his credibility into question.
That's okay. Am I allowed to do so?
Yes.
As of now? Okay.
I apologize. So the whole text says, at the time Portnoy distributed the offending memo to the public, she had already expressed disapproval of the curriculum change to her coworkers and principal directly, and to the public and school board through a published article in the local newspaper.
I do not have that. Can you reread that?
It is on the district brief, page 9. At the time Portnoy distributed the offending memo to the public, she had already expressed disapproval of the curriculum to her coworker and principal directly,
and to the public and school board through a published article in the newspaper.
Is this for the plaintiff? Is the title of this called Microsoft Word Appellant School District Brief?
Yes.
And this is for specifically the plaintiff, correct?
What do you mean?
Because in the email that we received, sorry, I'll let Chief Justice speak.
Quick point of information, I can go ahead and read the full line just for clarity, but the line that at which he is referencing does not automatically imply that the memo was published in the newspaper. Those were separate claims that the sentence made. So would you like me to repeat it a little slower? So you have it up.
I have it. The way that I interpret that is not that the memo was published, because it breaks it up with that comma there. It says the memo was distributed to the public, which I'm inferring is the distribution at the open house. The message of her disapproval was a separate thing given in the article, not particularly that memo, but it would have been, I'm assuming, the same message.
That's
so
fine. Yeah.
just change the language on
fine.
that. But
So his line of questioning, like even if we like deconstruct it, it's totally fine. Though my problem and scrutiny is with the witness actively complying with said rhetoric, despite it not being substantiated anywhere. So that is the line of questioning that
restrict
I'm
it.
criticizing.
Yeah, we can
so
redact
I would
it.
like to impeach the witness's
No,
credibility
we
or
can redact it.
restrict
Okay.
the witness's credibility. That's all I have.
So strike that specific line from the record, and then just you can re-ask that, but with different.
Yeah. Okay. Did you see the published article in the local newspaper?
Yes. To be clear, it wasn't the memo that was published.
Right.
It was
A
just an
different-
opinion. Yes.
It was a different. Was there any vulgar language, i.e., pile of garbage, or clandestine that referred to the Core Link program in the local newspaper?
I don't recall the exact contents of that newspaper, but I do know that those words were in the memo that was distributed to the parents.
Okay. And the memo was made public, correct?
Yes, anybody who could come to the open house, any parents who were interested in
Okay.
being involved, would get that memo. Yes.
And just to be clear, the memo is the one that had the discourse about it being a pile of garbage.
Yes, that was the specific line that was used.
Okay. As the school board trustee, did you have transgression, or did you have influence over the implementation of the program?
Yes. So what happened was in January of 2026, Mr. Skinner did a preliminary approval of this program, and that's his authority as the principal. What happens is the school board gives a final vote on the matter, and we did that final vote a few months later. And of course, we approved the Core Link program. So that's when it became official policy.
Did you read the memo as to why Miss Portnoy was unhappy? You did, right?
Yes, I did.
Okay. The reason she was unhappy, were they already addressed in the school board's factor into deciding whether it was a good idea?
Yes, the school board has a very rigorous process for these things. We hold a public hearing. She came to that hearing and she gave her testimony, she gave her comments, and of course she published her opinion in the local newspaper. And that wasn't enough to influence our decision. We still decided to go with the Core Link program.
So she did have a voice into the influence of the program. The school board just decided that what they thought overrode Miss Portnoy's question. Am I interpreting that correct?
Yes, you're correct. There was a school board hearing that was open to the public that Ms. Portnoy attended, and she did give her comments on the matter.
Okay.
Am I allowed to object to that claim really quickly? I believe it says verbatim that she was not accounted for in any capacity.
Where does it say that?
I believe in the bench memo here. I'll access it. Yeah, so it says in late January 2001, Principal Skinner tentatively approved the Core Link proposal without consulting Portnoy, chair of the math department, and a 20-year-old teaching veteran.
So the specific line of questioning that he followed was, or what the witness gave testimony of was that there was an open hearing that Ms. Portnoy testified at. That specifically says that Skinner did not directly come up to her and get her thoughts on it. I think that's two different two different things it's saying. I don't know where the evidence of that one is. That part might be improv, but I think that the Skinner not addressing her is different from a open hearing to
Okay.
the public.
Yeah, just for clarification. Thank you.
So this open hearing, it was open to the public and anyone can come, is that correct?
Yes,
sorry.
that's correct.
Okay.
It's a school board meeting, so anybody can come. Again, I don't know what kind of talks Mr. Skinner had with Miss Portnoy, but I know that she did come to the hearing because I was there.
Okay. So, given that she did not, her voice was heard, do you think it was unfair for the administrative staff to implement the implement the program anyways?
No, not at all. I mean, there's a reason why we have public comments is because we want to hear people's perspectives on different matters. But the thing was, she wasn't able to persuade us, and that's just how things work out sometimes. And so, no, I don't think that's fair. That's why the school board is here. We vote to make these decisions, and people can comment on them.
Do you know why she was not given that she was an executive position in the math department, do you know why she was not given a influential role into the program?
Well, it's because the school board makes that decision. It's not particularly up to her. She can write to us. She can, provide comment. And of course, as the principal of the school, Mr. Skinner has the authority to tentatively approve a program. But of course, the final decision is with the school board. So that's me and my colleagues.
Okay. It was one of the DA's testimony, I believe it was Kyle Curtis, who said that the school board was pretty cold in informing people or parents about comments about the type of education that we're doing and the official lesson plans. Do you know why that is?
Well, I mean, we don't have the Ringling Brothers Circus doing entertainment for us at these meetings. It's kind of boring, and so I think that might be a part of it. But I don't know why he would say that it's particularly cold. I think we do our business and we keep it open to the public. We do it the right way. But that's about all I can say to that.
So it is made public, right? The actual Corling program and the board of trustees deciding on that information is made public, correct?
Yeah, of course, it was all publicized, and that hearing, of course, was public. People were able to give their comments on that, and of course, Ms. Portnoy did and come and give her comment on that matter.
Did you go to the open night on May 9th?
No.
No. Did you hear about did you yourself get a chance to look at the pamphlet that was distributed to the parents?
Yes, I did. That was one of the pieces that we looked at during Ms. Portnoy's disciplinary hearing.
And what was the consensus that the board came to at her hearing?
Well, the consensus that the board came to was, of course, Ms. Portnoy has the ability to exercise her First Amendment right, but there's a time and place to do that. And as a professional for the school, she was operating in her capacity as a teacher during that time, because open house is contracted work time. That was not something that was appropriate, especially considering the amount of public backlash and outrage that caused. We thought it took away from the educational environment to be disparaging her colleague like that, and so that's why we made that decision.
Okay. The public hearing, was the other department heads, were they also at that hearing?
I wouldn't know. There were a number of people who watched that hearing, but I couldn't tell you who was actually there.
But you know for sure that Ms. Portnoy was there?
Oh, yeah, of course, because she was the one being disciplined.
I'm referring to the...
Oh, the other hearing?
Yes.
Oh, yes, she was there at the public hearing to give comment.
And the rest of the department heads were also there?
I'm not exactly sure. I know there were a lot of people there to give public
Okay.
comment, yeah.
But you were there, correct?
Yeah, I was
Okay.
there because I was one of the board members.
Okay. And at this hearing, the board members, they all collectively decided that it was best to implement this program? Is that
Yes, that's what we decided. You see, the status quo system that we had before CoreLink, we were just seeing disparities in testing outcomes for different minority groups, and so we thought it was best to make a change and try something new.
Did
That
you?
is time.
Okay. A point of information. Are we allowed to? We are allowed to redirect witnesses, right?
If you so desire.
Does that come before jury questions or the judge questions or after?
That would be beforehand.
Okay.
Mr. Abraham, you are allowed to now cross-examine.
Yes, of course. Thank you so much, and thank you for coming on here to testify. I would just like to ask a very brief question concerning clarity. So, what derogatory comments did Ms. Portro insinuate that would constitute her demotion?
Well, she said something along the lines of it being a garbage program, and she also said the decision was made in a clandestine manner, which was absolutely not true because she was at that public hearing and she did make her comment. There were plenty of people there.
Yes, of course. So then I would ask, as for the comment goes mentioned in her memo concerning pile of garbage, was that directed at a group of individuals or any specific independent person, but rather in a program?
I don't know her intention.
So you don't know like the literary context of the word and what it was referenced to. So what did the pile of garbage comment coincide with? What
It was about the program, I think.
Okay, so what other comments did she make that would constitute her demotion in terms of hate speech?
Well, nobody's saying anything about hate speech here, just to be clear. We're just saying that violated the professional conduct rules we have at that school. Among the other things, she called it mean-spirited, which I think was directed at our principal, Mr. Skinner. And the other thing, of course, is she said that the school board made the decision in a clandestine manner, which was not true.
So professionalism is your only ruling framework to determine why the demotion was justified then, correct?
Yes, if an employee is not professional and they're disparaging their colleagues and is causing a public outrage, then I think that's worthy of a demotion.
Okay. On the lines of public outrage, what empirical evidence do you have to define if a public outrage occurred?
Sir, I don't have empirical evidence.
Not empirical evidence, but just any reference point that you could use to constitute a public outrage.
Sure. As a school board member, I interact with a lot of parents, and I can tell you that there was a lot of public outrage at that meeting. People were very upset about the CoreLink program. I'm aware of this stuff. I work in this field.
Was that insinuated by the plaintiff, or was that outrage concerning the program itself?
I can't tell you why every person there was outraged, but I do know that her publication in the newspaper at least reached a few people. That could be a part of it.
So could you think people were outraged by the program because it wasn't substantial enough to be integrated?
Can you clarify the question, counselor?
Yeah, so would you affirm the contention that people were upset with the CoreLink program because it wouldn't work and it did not have any empirical backing to substantiate its ratification? Would you have any reason to doubt that?
Sir, I can't speak to why.
Objection calls for speculation. The witness can't speak to why people act the way they do.
Mr.
There could be a
Abraham,
number of reasons that they show up to a public hearing.
Yeah, so I wasn't making that point. I was saying in his own perspective, does he have a reason to affirm or deny?
I cannot remember the specific wording of that question, so I'm just going to say rephrase that question if you want to ask it.
Oh yeah, I would just skip over. It wasn't really too topical. Moreover, you mentioned the logistics of a public hearing. So, what is the difference between an individual being consulted executively, or what is the difference between an executive consultation and having a presence at a public hearing?
Sir, an executive consultation, can you clarify that?
Yeah, so let's say someone had a leading role, as Ms. Pointer did, in the math department. So what is the difference between consulting her on the behalf of her executive role in the math department versus her as a citizen in the public hearing?
Oh, okay, yeah. So those public hearings are open to anybody. Anybody can make comments. So that was her right, and that's what she did. But I guess in terms of what her role as the math department head plays in that, she doesn't get any extra sway at those meetings because, of course, it's not her role. She's not in an elected position like I am. But I suppose she would have some sway with Mr. Skinner. Because he's able to preemptively approve some policies until the school board makes a decision on that.
Yeah, so did you have like any substance to her argument right then and there based on seniority or her status, considering that she served on the math department for 2 decades? Was any of that or her status as a teacher considered when she made this decision, or were they only taking it on account as a public citizen?
Well, I can say personally, I can't speak to the rest of my school board members. I can say that definitely gave her a degree of credibility when she was testifying and giving her comment in my mind. But I can't speak to how others view that and how others made that decision.
Okay, would you also additionally affirm that anyone can testify at these public hearings and they cannot be denied from testifying so?
Yes, of course.
Okay, so with that being said, in her executive position, how would that differ from her role in the public hearing then? Because just because she had the ability to speak in the public hearing does not automatically substantiate the fact that she had a role, because you guys cannot turn her down. So again, what is the difference between her being considered as an executive individual versus her speaking at this hearing?
Once again, the hearing is open to the public, so anybody can make a comment there. But in terms of her role as an executive, she doesn't have any decision-making power in that aspect besides whatever sway she might have with Mr. Skinner, because Mr. Skinner is the decider for the school. He's the principal. Whatever sway she has with him, that's as far as her executive capacity goes.
So other lines of scrutiny came from the plaintiff witness one named Michael Albert, who deliberately testified and made the claim that the principal considered all testaments from every single department in the ruling decision process, right? So again, with that accounted for, do you have any reasons as to why Ms. Ponier was specifically exempted from that, if all departments were consulted from, according to Michael Albert?
I'm not aware of the internal affairs or the internal politics of what happens inside Silver State Middle School. I'm a school board member.
So why are you qualified to speak on this then?
Sir, because I was elected to this role.
You were elected to this role, but you just conceded with the fact that you don't have like not every single, but tangible logistical components of what happens within the school. So a lot of my questions that I asked concerning like the internal relationship between Ms. Poniard as well as the principal, et cetera, you were unable to answer. So with that said, what substantiates your qualification to speak on behalf of this court today if you don't have any interaction with the middle school on an individualistic level?
Sir, there are many middle schools in this district. I can't interact with every single one of them. And what qualifies me to be in this position is that I was elected by the public.
Yeah, so with respect to the testimonies given on the behalf of Ms. Ponyar and their dynamic as well, would you also affirm that your role is kind of more passive then, and you don't have as much knowledge as people who actually work inside the facility on this dilemma?
I'm not aware of the internal politics of Silver State Middle School, if that's what you're asking me. I just know what happened in terms of the of the disciplinary decision and what happened at the public hearing.
So why don't you have knowledge about the internal politics? Just one more time so I can document it.
Sir, because there are 20 middle schools in this district, and I don't have time to know every single person in every one of them.
So along similar lines, then, why are you qualified not as an individual who, for the purpose of the board, but as an individual who is qualified to speak about this hearing, when there are other individuals who have more, I guess, individualistic knowledge about the case?
Sir, ask Mr. Kung. I was subpoenaed to be here.
Okay, phenomenal. I guess that would be all, considering the individual is not well versed in the internal dilemmas of the case. So I guess whatever time I have, I would concede.
Strike that last statement.
He just conceded with it, though, so you can't really move it if he admitted to it.
What is your grounds for objection?
It's fine. Can I ask redirect questions then?
If you so desire. But then he will also get recross.
That's fine.
Cool.
Point of information, what is the recross again? Is it?
He's just gonna ask a few more questions, and then you can ask more questions based on what he asked. You'll
Based
have
on- okay. That's good.
you have 5 minutes.
Okay. So you were part of the trustee that put forward the Core Link program, correct?
Yes, I was one of the people who put forward that program and approved it.
So what does this board do when evaluating it? How does it determine the desirability of the program?
Well, I mean, we're really looking at the context of what's happening in the school district right now. Right now, there's a huge performance gap between different minorities, and we want to make that gap smaller. So the current system isn't working out, and so in the context of what is currently happening in our school district, we want to adopt a new system that we think might be effective. And that's why we decided to implement the Core Link program.
Which was a trial run, correct?
Yes.
The public hearing for the demotion, were you also a part of that?
Yes, I was a board member who made a decision. I heard all of her testimony.
It was one of the parents' testimony that she said, or Miss Portnoy said that called the principal an autocrat. Was this a factor in the public hearing?
It was not a factor in the public hearing where she made comment, but in the disciplinary hearing, that was one of the things that we factored into our decision, because we believe that calling your boss an autocrat publicly is not something exactly becoming of our professional standard.
And under that professional standard, is it, or what constitutes the professional standard?
Well, I'll tell you, for one thing, disparaging your coworkers is not professional. You just generally want to conduct yourself in a manner that represents the Silver State School District in a positive light.
That's all the questions I have.
Thank you, Mr. Kung. Mr. Abraham, you may now begin 5 minutes of recross.
Okay, my time will begin on my first word. So Silver State Board Executive Director, I guess, or executive position role. What would you say, to ask another question, did Ms. Partner instigate anything that would dismantle the educational success of the facility, or was it only on the grounds of professionalism amongst her coworkers?
I mean, no, we didn't think she was going to destroy the school. If we thought that, then we would have fired her, not demoted her. She was just demoted from the head of the math department because of that violation.
Okay, so you didn't believe that she would cause such an imminent risk that would require her exhaustion then, right? Or her dismissal?
I mean, we didn't think the school was going to blow up, but obviously it was a problem, and there was a public backlash.
So again, it was within the bounds of the professionalism that your board strives to maintain with its colleagues then, correct? That's what basically substantiated the demotion, correct?
Yes, that was the whole point, that it did not fall within our standards of professionalism. That's why we demoted her.
Okay, and then you had also mentioned that she called the boss an autocrat, correct? Or Principal Skinner, I believe?
Yes, she called Mr. Skinner an autocrat for making a decision that she didn't agree with.
Yeah, so would you believe that in no capacity that statement or that description could be justified?
I mean, I don't know how Mr. Skinner makes his decisions. I know that he brought all of the heads together, and they made a decision on preemptively passing that policy. So I guess I wouldn't consider him an autocrat, but we're all entitled to our opinions.
Yeah, so again, if the description was justified to any capacity, would you then render the decision to call him an autocrat permissible?
Well, no. Regardless of whether or not he's an autocrat, we have professional standards. That's not something you do in public. It scares the students. It scares the parents. It's not good for our school district, and that's why we don't allow things like that. When you're at work, at least, you're working in a professional capacity.
Okay. And then we are going to discuss the logistics of the Core Link program. So it has been a recurring theme throughout this committee to discuss the empirically backed evidence that would, again, substantiate its ratification. So did you guys, your school board, as well as with Principal Skinner, conduct like an independent study to see if this new program was going to work on the scale at which it was initiated, or was it on pure speculation?
No, it wasn't on pure speculation, but we're doing it as a trial run because we don't really have any of that. We didn't think it was necessary. We're just doing a pilot program right now. It's
So
pretty
it-
standard.
Yeah, so in the event that it does not work, would the administration then dismantle it?
Yeah, I mean, that's definitely an option. We might go back on our vote.
Okay. And just for one quick clarity, all the like the logistical questions about like the internal complications of the school, you would not have an answer given the fact that there are 20 schools across the district and you can't oversee each one independently. Is that true?
Yes, I don't know every
Yeah.
personal problem that every principal has with every head of the math department.
Okay, yeah, that's perfectly fine. Okay, that's all I would have then. Thank you for clarifying.
Thank you, Mr. Abraham. We will now begin judge questions towards the witness. Start.
This is a, we can ask questions to them, right? Yeah. Okay, this is a question to both, attorneys. Could each of you please clarify, give a definition for the word derogatory?
Oh, I could. So a derogatory statement is a statement that is made to insinuate aggression and or bigotry, hateful behavior to an individual. Derogatory comments or a program at that, but derogatory comments are usually fitting that description.
I did not use the word derogatory, I don't think, but I think I have a similar opinion. It's expressing a low opinion or being disrespectful or aiming to belittle someone's reputation.
Thank you.
So does the school board, the school board works for the best interest of all of the schools in the district, correct?
Yes, we work for the interest of the public.
Okay. Were you, did any parents come to you and talk to you after either the public hearing or the disciplinary hearing?
I mean, there was none that talked to me personally, but we had testimony during the public hearing about the Core Link program.
I mean specifically like regarding the plaintiff. Like, did any parents talk to you or any of your coworkers or anyone about this?
Not about Miss Portnoy specifically, but there was a lot of public outrage about the Core Link thing after some of the things that Miss Portnoy published. I don't know if there's a connection there or not, but that's just how it went down.
By public outrage, do you mean like her letters in the mail, or what exactly?
Once again, I can't say what that public outrage was caused by, but there was public outrage around the time Miss Portnoy published her article in the newspaper. It seemed a lot more people were upset about it. I don't know if that's because more people were aware of it or because they agreed with her perspective. That's just how it went.
Did you hear about this outrage, or did you actually like see it?
No, I actually saw it.
Oh, okay. Thank you.
When the board is making decisions, is it ever customary to let the staff of the affected school know about those decisions or not?
Yes, it's always a public announcement. These are always public things. You can come into a hearing or a disciplinary hearing, and you can spectate because we do serve the public. And I mean, we don't exactly do a press release, but it's public, and everybody can know about it if they want.
So when it comes to the case of the school board approving the Core Link policy, did the board ever deviate from any policies when it came to Patricia Pornat, or no?
Deviate from any policies in terms of what?
In terms of alerting her to what was going on.
Oh no, we did a completely standard disciplinary hearing. I mean, this type of thing happens all the time. I mean, not every case goes to the Supreme Court, but you know, this is a relatively common thing.
Thank you.
Mr. Taylor, you may step down.
Thank you.
Thank you. All right, I will now give both the plaintiff and the defense. You'll have 10 minutes for a closing statement, and then we will move into our deliberation. So,
Just a quick question of clarity. So are we able to request prep time for these closing statements?
countersuit will happen after this case. We have, it's 2:50 and we have basically hour and a half left. This shouldn't take that long. So I would say we're gonna run it. It might be like 45 minutes, 30 minutes, but we'll try to get it done. I'll give you minute 30 of prep time.
Okay. When does that start now?
Starting
Okay,
now.
thank you.
Point of clarification to the counselors. Counselors, do we need a unanimous decision or can it just be a majority? Awesome, thank you.
That is the end of your time.
Mr. Abraham, please begin your closing statement.
Your time will begin. Your time will begin on your first word.
So the plaintiff feels that there has been some disconnect. Remember, the original rhetoric is whether her constitutional right and her First Amendment was violated. To prove that her First Amendment was present and violated, we must further address the prickling case. And two components both me and my opponent have agreed upon will be discussed in the following. One, she did things for the common good, and her speech reflected it, as well as any other rhetoric that she coincided with. Entering the facts of this debate, she is a senior official. She has 2 decades of election experience, and she also shares the highest position in her math department. She also shared numerous initiatives to publish reports and booklets to inform and synthesize the community, all of which being empirically driven. Entertaining plaintiff witness 2, Ms. Potney is infamous for educating students, specifically witness 2 daughter, as he described her as very strong-spirited and exemplified a steadfast commitment for student education. Kyle Curtis strongly affirmed that transparency was not retained on the behalf of the school, and thus her efforts to bridge the gap of knowledge were indicative of common good. The document felt personal, which was rooted in concern rather than personal gain. Witness 2 also affirmed that there weren't any direct references to one specific person in attack, as also affirmed by plaintiff witness 1 and defendant witness 1, as the program was the only thing appropriated as hot garbage. The only mention of an attack on the behalf of the person or faculty was when the autocratic nature of the principal was discussed. Her booklet, moreover, is also empirically driven, and thus proved to be for the common good. The quarreling program was not accompanied by any evidence, as affirmed by advocates of the group, such as plaintiff witness 1 and 2, and defendant witness 1, as well as the Silver State Executive Board member. The only rebuttal here to the moral worth of her advocacy was she lost a consultation with the board department, but that doesn't diminish intent. School board members across the nation have historically imposed inadequate policy, particularly concerning race or financial class. Just because they don't rule with her does not exempt them from being challenged. We have seen school boards in every case presented being challenged, as it is here. 2, the logistics of her speech outside the singular isolated incident of pile of garbage did not contain vulgar language, as those who attended the orientation have referred to it as better spirited. The only other form of vulgar language from the orientation or any sort of hearing that the committee can attest to was brought forth by defendant witness 1, stating that Ms. Portney had referred to the principal as autocratic. I believe the statement is objectively justified, and the principal strongly exhibited authoritarian characteristics by failing to account for the perspectives of all people. My opponent refuted by mentioning the principal accounted for other departments, but my opponent cannot verify if this decision was made as a bipartisan account, as the only person who was empowered to a position of consideration within this committee was plaintiff witness 1, who agreed with the principal regardless. Because the principal only empowered those who agreed with him and not the majority, per verifiable information, his behavior is tyrannical and thus cannot be written off as defamation since it is objective. Next, the interests of Ms. Portney outweigh the interests of the school. Her priority of educating students and prioritizing those who are being served by the government naturally outweighs the interests of the school. The school seemingly only values the public image of the institution, not the well-being of the students, as my opponent has failed to prove how Ms. Potney's advocacy impeded the success of students and the institution alike. Whereas Ms. Potney solely prioritized the academic excellence of those she was serving and the institution was serving, as those are the people who, according to plaintiff witness 2 and defendant witness 1, were not informed about the structural components of the core link program. Gauging that scrutiny helped to prompt the growth and stability of the institution. The secondary intent claim will hereby also be substantiated. The school really doesn't have protective interest. Remember, the trickle case satisfies 2 components: 1, intent of common good, and 2, a protective interest that is weighed highly on a moral compass. Since they did not take immediate action when the plaintiff had referenced the only form of verifiable hate speech, being quoted as heart garbage. This wouldn't be considered as a tangible form of hate speech, however, as it wasn't directed at a cohort of people rather than an academic program. Per constitutional amendments, one is still entitled to their First Amendment right as long as hate speech is not insinuated on the behalf of an individual. Calling a program hot garbage is not indicative of substantial hate speech to that degree that would ever verify or would ever substantiate a demotion or interdisciplinary action as well. If the school board genuinely had a priority to preserve the academic stability and was severely damaged after her comments, it wouldn't have run so smoothly following the open house, according to witnesses 2 from plaintiff and 1 from defendant, and they would have fired her right then and there. They only chose to fire her when the public image of the school during the open house would have been at stake, not when she first made the comments before the open house, which the defendant claimed had trickled down and ruined personal relationships. If this was the case, it would have been more justifiable in the interest of the school to fire her or demote her right then and there. Why wait after the fact during the open house to constitute any action? That substantiates in itself that the school board did not have any tangible interest of preserving the academic well-being and the social mobility governmentally of the students of the academic facility, which Ms. Ponyer has consistently exhibited that she puts the students first regardless, as elicited by nearly every single witness that had a tangible interaction with this person. Moreover, again, which the defendant had also claimed had trickled down and ruined personal relationships, which, again, has no tangible backing. In synthesis, that is more indicative of consolidating personal motivations rather than the stability of the institution. My opponent has not specified as to how the alleged discourse that Ms. Protney instigated compromised the mobility of the classroom, as witness 2 from plaintiff had directly stated that the faculty retained professional and classrooms independently operated as normal, despite the initiation of the core link curriculum and the discourse Ms. Protney had allegedly caused. I additionally would like to dismantle other claims made on the behalf of Silver City School Board Executive and the dilemma surrounding public hearings. The plaintiff believes that there is a difference between voicing an opinion at a public hearing and one as an executive official. The individual testified, the witness, the executive board member, he did not have any further insights on who was consulted. But from plaintiff witness 1, we can confirm that all departments had executive decision making. Moreover, it is mandated that anyone who attends these hearings has to be recognized, right? But that doesn't automatically mean or precipitate that her testaments were accounted for. Moreover, it has remained clearly indicative that her testaments were the only ones that were dismissed and isolated. Moreover, again, she was not consulted prior to the ratification of this policy. You would think that one that synthesizes very well with the math department would ever constitute or would ever substantiate the collective decision-making process on the behalf of school board members. And because the plaintiff had just proved that Ms. Potney acted in reasonable cause on the behalf of the common good and her ambitions outweighed that of the school administration, she is entitled to her First Amendment right, thus proving the case was a breach of such. As such, this closes my closing statement, and thank you so much for empowering me to this position.
Thank you, Mr. Abraham. Now, Mr. Kong, you may begin your closing statement.
Can I get prep time?
Yeah, we.
That's not.
So he was point of information. So I believe what we have established is that when we are given prep time periods designated for the speech, it is supposed to be used by the both of us. And regardless, he was working during that time, as everyone had clearly seen. So I don't believe that he is entitled to more
He
prep
was
time.
given. I haven't heard his closing statement. I should be given time to be able to reflect and rebut his closing statement. His rebuttal was he was given prep time to respond to the witness testimony. I should be given prep time to respond to his closing statement.
Oh yeah, you can do it then. That's okay.
That's fair. I mean, we did this earlier. We gave you a minute 30, so we'll grant you a minute 30. Your time starts now.
Point of information, is there another additional speech toward the end of this hearing?
After this, it's just deliberation.
Deliberation, what does that entail?
Us. coming
Oh,
out of
okay,
this
okay,
and-
phenomenal. Thank you, by the way, Your Honor.
You're welcome.
I'm ready.
Mr. Kung, your 10 minutes starts now.
The question in this case is not whether Ms. Portnoy should have been consulted, but whether demotion was justified under the First Amendment. It was completely just. The DA's witness, Michael Albert, said the principals are allowed to go over department heads. What Mr. Skinner does was in complete compliance with professionalism, which means that Ms. Portnoy's pamphlets and memos should be the first invocation you mark as unprofessionalism, which means their response to demote her was justified. 3 things I want you to remember in this case. Michael Albert is a witness for the defense because, again, whether Ms. Portnoy should have been consulted is irrelevant to the question of whether she should have been demoted. The only thing you need to remember from Michael Albert's testimony is that principals are allowed to go over department's head. The second one, Mr. Curtis was angry at the school system for something he learned from Ms. Portnoy. But every reason Ms. Portnoy gave, she gave at the public hearing, and it had already been reviewed by the Board of Trustees. According to Mr. Taylor's testimony, they just decided that the government's interests were more important. The third example is the Pickering test, which the second quote links to. The government's education values outweighs. Even at face value, the government will decide with the best decision for all subjects. And Portnoy's only extends to math curriculum, which means that even at face value, it is not true. But they failed to address the matter if it is a public concern. The board already decided on it. They already talked about the stuff she was complaining about and decided not to vote in her favor. The government's interests have superseded her own interests. So we've established it's not outweighed by the government. So the only question in this case should be whether the language she uses should be enough to demote her. She called him an autocrat. I'll explain more when I get to my analysis of Robert Hill, but now I'm going to go down the line. They said that the common speech was a common good and speech reflected it, but the speech was unprofessional. The details is not whether the speech was good, but whether it is unprofessional and caused public unrest. The second is the third point he goes to is there's no reference to a specific case. Mr. Hill testified to hearing Ms. Portnoy say that Skinner was an autocrat, which means that the next point, when they say logistics of speech should be objectively justified, they need to hinge the way you vote on this on whether or not he is an aristocrat. But remember Michael Albert's testimony that the principals are allowed to go over department's head, which means it does not matter if Ms. Portnoy views one way because the principal has power over them, which means nothing he did was unprofessional. They said then the defense said, the DA said that Ms. Portnoy's arguments outweigh. Wrong. Ms. Portnoy spoke at the hearing, and her reasons were already taken into account. The board just decided to not go her way. Then they said that you should vote voicing an opinion, and anyone who attends the public hearings should be able to talk. No one said that no one else's public voting was not taken into account. It was just outweighed by the government's affairs. I'm going to go through each witness now. Michael Albert, this one should be a game over for you. We talked about the defining of professionalism. It's the strict adherence to skill, competence, ethics, and polite behavior expected from a trained person. But it was his testimony that principals are allowed to go over the department heads, which means that Mr. Skinner's professionalism was true and he was acting in a professional occupancy. And even if it was just a trial run, if this was just a trial run, why did Ms. Portnoy directly say, why was it Mr. Hill's testimony that Ms. Portnoy directly called him an autocrat and used that much of that vulgar language? If she knew it was going to fail anyways, why could she not have just waited and instead not used that vulgar language? The next witness is Kyle Curtis. Given that Kyle Curtis said he got all of his information from Ms. Portnoy and led to his disdain, it can be reasonably inferred that his belief in the system was jeopardized by Ms. Portnoy. I said it in the opening statement and argument statement that the trust in the belief system of the education system is key. He also claims that the school was as professional as it could be there in his times. That means every instance of confrontation he had with teachers between the time when the program was implemented and opening night was professional, and that there was only unprofessionalism after the fact that she made those benign comments and the pamphlet. He says that this is dislike for the program and not disdain. But how can you delineate the difference between those when she called his pamphlet a pile of garbage and clandestine and directly called him an autocrat? He then goes on, Mr. Curtis then goes on to say that the administration as a whole handled it. Wrong. The facts of this case explicitly outline that Ms. Portnoy's packet, printed on the letterhead bearing the school name and the official chair title, contained criticisms of Principal Skinner and other Silver State teachers and the school board's decision, which means that the packet had direct implications as to calling him an autocrat and direct implications onto his character rather than just his program. The next question we should concern ourselves with is, why did she hand out 2 packets? Why did she hand out something that was already decided on? When Mr. Curtis was asked by the judges what he thought about the pamphlet, he said it was what we needed for this situation. How can he make this claim when he is the one that admitted that he didn't really know about school procedures and only heard about them from Ms. Portnoy? The judge then asked him to ask his relationship to other parents. He said it was very frustrating to hear that the program was bad when you put your kids into school. Most of them were, quote, checked in, which means if it's instructed by a 20-year veteran teacher that the school system is a pile of garbage, that their belief in the education system would be devastated. The witness testimony is on the side of the defense because it is only true that there is public unrest because of the teacher. The next witness is Robin Hill. Unprofessionalism made me doubt her own words. The state of the program was bad. He had doubt as to whether the analysis of the program was true, which means he doubted Ms. Portnoy. Unprofessionalism leads to these doubts created in this doubt in the school system. Star this on your notes. The witness said that Ms. Portnoy called the principal an autocrat. For reference, an autocrat means a person, system, or leadership style that possesses absolute power and demands complete obedience. It is obviously unprofessional to call your boss a person that demands complete obedience. It obviously makes parents feel like their school is a dictatorship. And who would want to send their kids to go to school there? A principal should be personable in understanding his kids. The direct calling of him as an autocrat is why we are suing for defamation and why she was demoted. The obligation to step in argument. The case is not about it. It's whether or not the demotion was justified given the language that Ms. Portnoy used, calling him an autocrat. The last witness was James Taylor. As a school board member, public hearings, remember, again, it is Michael Albert's testimony that the principals are allowed to go over department heads. This is terminal defense in the trial to prove he was not an autocrat because he was justified in doing so and going over the department's heads. You cannot call him an autocrat regardless of whether or not he is to public people. You work in a professional capacity. You should not be calling your boss an autocrat especially when you are a teacher and there are parents who listen to you. Remember that they have hinged this trial on whether or not he is an autocrat or not. But the board deemed he wasn't. Otherwise, they wouldn't have demoted Ms. Portnoy and instead fired Mr. Skinner. The only things you need to remember about this case is that Michael Albert is a witness for the defense, and that James Taylor is a board member who determined that it was wise to demote Ms. Portnoy. I rest my case.
Thank you, Mr. Kung. We will now deliberate as a panel, or as, what would be the right way to say that? Okay, as a panel of justices. Thank you. Order. We have come up with a decision. I believe it was unanimous, correct?
Yes.
Okay. So, in the case of Silver State School District versus versus Portnoy, there we are. The court rules in favor of the defendant. The words themselves were not the problem. The fact that Mrs. Portnoy berated the school district during contracted hours, as stated in Conic 461 U.S. at 152, 153, manner, time, and place is the issue. Additionally, seeing as she did it upon contracted hours, she is not acting as a private citizen. She is acting as a government official. Therefore, she does not pass the second part of Pickering's test. Yes, the contracted hours is the issue. Additionally, there's reasonable concern that Mrs. Portnoy's speech caused public harm. In addition, in the ruling of Waters v. Churchill, it said that they do not need evidence of harm. They just need a reasonable suspicion. And seeing as there is testimony that it did cause some harm, and there is reasonable suspicion of harm that could be caused, we find in favor of the defendant. Thank you.
Point of information, are we going to go to the defamation case now? Or? Okay.
The court will recess now.
Point. Point of information. If he is countersuing for defamation, wouldn't that make him the plaintiff? Or the prosecutor? Or whatever the term is. Okay, so he starts with his... Okay, phenomenal. Point of information. So is the questioning period delegated amongst the Supreme Court and the representative, or among the representatives? Okay, thank you, Your Honors.
All right. Now for the case of Silver State Schools versus Portnoy. For defamation, we have Silver State Schools as the or is it prosecutor? Prosecutor? Or plaintiff, sorry. Silver State Schools is the plaintiff, and Portnoy is the defendant. We will start with a argument from Silver State Schools District. Thank you.
Point of information for like the counselors. So how much time is delegated per speech and questioning period? 5 minutes, like okay.
We're gonna do 5 minutes for speech and then 5 minutes for questions afterward. Thank you. Mr. Hung, Mr. Kung, sorry, oh my, it's Mr. Kung.
All right. You ready?
Yes.
We wish to sue the prosecution for $50,000 for defamation of character. Ms. Portnoy had no reason to publicly scrutinize our school's board math curriculum, publicly call out Mr. Skinner as an autocrat, but decided to do so anyways, calling the principal's work a pile of garbage, clandestine, and amongst other vulgar language, devastating the reputation of Mr. Stinger. As a teacher, you have power. You have a responsibility to protect the education of a new generation. The burden of proof. One is the false statement. The defendant claimed the principal was an autocrat, but it wasn't. Given the witness testimony from their witness, he said that the principals are allowed he said that the principals are allowed to go over the department's heads to make this deliberation, which means that he wasn't an autocrat and he was exercising his power invested him as a principal. 2. Unprivileged publication. The statement was communicated to a third party. I think this one is pretty straightforward. She talked at an open house where she publicly handed out newspapers and orally called him an autocrat, criticizing his work, his character, and his morals. 3 is the fault. The defendant made the statement intentionally, negligently, or with reckless disregard for the truth. He wasn't an autocrat. She knew it. She just didn't want to work more. It was, again, the witness testimony said that it is up to the discretion of the principal to see whether they can go over the department's heads. The last section is damages. The statement caused presumed harm to your reputation. What do you think happens when an esteemed 20-year veteran, a teacher, who everyone follows, given the testimony of Mr. Kyle Curtis and Mr. Robin Hill, what do you think happens when a 20-year veteran teacher calls you an autocrat and calls your work a piece of garbage? Given this, we think that his reputation would be damaged, and for compensation, we wish to sue the defendant for $50,000. Thank you.
Thank you, Mr. Kung. We will now start asking.
Point of information. Am I allowed to request prep time before my speech goes? I know I'm not going right now.
We're going to
so I
ask
think-
him questions, so you can use that as your prep time.
Okay.
So, going back to the first point, false statement. The defendant made a false and defamatory statement of fact. So it's your belief that she's not that the principal is not an autocrat, correct?
Yes.
Okay. And that's the only thing you're going to be referencing? Or are you also going to be referencing the pile of garbage statement?
No, I'm not going to be referencing that. That is evidence for, like, why there was presumed harm to the reputation, but for the false statement is that he was an autocrat. I think like the pile of garbage is up to the discretion of like whether it influenced his character, but I think the main point is that she publicly called him an autocrat.
Okay, thank you.
So, you say that the false statement of autocrat devastated the reputation of the principal, and then went on to say there was presumed harm. Can you justify why you believe $50,000 is an appropriate fee? And also, can you explain how some of the harm may manifest, or may have manifested?
Yes. We thought that there was a risk that as a result there would be public outrest and he had the potential to be fired. In the case that he would need compensation enough to find him a new job. So we think that $50,000 was reasonable.
Thank you.
So I would just like to ask, it's a question, then she did not say he was an autocrat. She said that, I'll just read off, and criticizing Skinner's high-handed and autocratic management style for approving the proposal without her input. Do you believe it is, do you believe she's calling his entire management style autocratic, him an autocrat, or just a portion of his managing style autocratic?
I disagree. We have witness testimony saying that they were there and they were parents of the opening night where Mrs. Portnoy called him an autocrat.
Okay, thank you.
Also, it's just a false statement. Even her saying that he's autocratic could be interpreted as false. I kind of. It's a little more washy. I also had one question. So part of this is that the statement has to be communicated to a third party. And if I remember correctly, judges correct me if I'm wrong. This autocratic statement was made in the pamphlet, correct? During the speech at the public hearing?
It was the third witness testimony that said that he was called him an autocrat. But there's also in the fact of the summary case that says that he attacked. Give me 1 second, actually.
I can read the bench memo. It says, Portnoy circulated a memo to all faculty and staff that she further objected to the core link proposal, calling it a pile of garbage and criticizing Skinner's high-handed and autocratic management style for approving the proposal without her input. So she does express the autocratic to a third party. In addition, she also shows that to the public. So that's my note.
Would we consider the audience a third party if it was meant to be for the audience? Because
The two parties that they refer to is the party of the principal and Ms. Portnoy. Anything else between them is a third party because it's a third body that they would hear this information from.
got it. Thank you.
We are at 30 seconds.
I think it also should be noted that on Portnoy's packet, printed on the letterhead, it contained criticisms of Principal Skinner.
Where does it say that? I'm sorry.
Appel School District Brief, page 2, the summary of the argument. Sorry, it's the section above summary of the argument. The paragraph that starts with on May 9th, 2001.
Thank you. Time is now done.
Thank you, Mr. Kung. We will now move on to Mr. Abraham's argument and then questions. Thank you.
My time will begin on my first word. So before classifying any action as defamation, it is imperative to define the prerequisites for constituting such, which my opponent failed to do. Per constitutional ruling, one must prove how harm is a constituent of a statement, for example, proving job losses or other related discourse. This is what the federal government has deducted defamation to be at the grassroots, and so if my opponent cannot tangibly prove that a related discourse or detriment stemmed off as a byproduct of the defendant's claim, then therefore their claim is nullified and cannot be testified tangibly. Again, my opponent cannot prove how harm was a byproduct of the defendant's testimony, as numerous witness testimonies, in fact, have affirmed that the school operated normally, and no discourse have stemmed off the statement. My opponent more so acknowledged that harm could happen, but it didn't actually happen. Her constructive critique was more opinionated, and she didn't make any objective claims, and she more so just attacked his style of rule. And again, my opponent has failed to acknowledge that the principal actually exhibited autocratic characteristics. Regardless, and while it is a claim that should be taken seriously before the court, it does not automatically presume defamation. I mean, it does not actually justify the excessive amount of fees that ought to be paid, given the fact that my opponent cannot prove that harm or any related harm stemmed from his character has actually occurred. It is more so just the risk of happening. Again, I would just like to respond to some of my opponent's claims made. So he discussed the burden of proof. A witness testimony had announced that principals are allowed to go over department heads. And again, this is referencing their broader authority to isolate the exact incidents. You would quickly realize that that is not actually in line with what occurred. The principal wasn't going over the department head. He just blatantly did not consider her testimony to any capacity. If the testimony was considered and he decided not to rule in favor of it, that would be an example of how a principal or a ruling official can go over someone's head. But he blatantly did not consider, and in fact, he actually exempted her from the executive decision-making process concerning a pivotal piece of programming legislation within the school board that would decide and dictate the futures of numerous parents and children alike. Moreover, he also mentioned, or the opponent mentioned, the opposition, talked about how she talked at an open house and orally called the principal an autocrat and his morals and attacked and made a reckless statement. Again, you can acknowledge this all you want regardless. I am substantiating the fact that this was an opinionated claim. At the forefront, you must prove that harm precipitated or was a byproduct of said statement to actually support or affirm the designation of such a large sum of money, as well as the claim of defamation, right? You can discuss how this was a logical prerequisite for demoting the teacher itself, but that does not automatically suggest defamation, because defamation is under the burden of proof of that harm was caused as a byproduct. Again, my opponent to that claim said, and I quote, it presumed harm to reputation, but again, there have been no claims or no empirical evidence brought forth from this committee that have actually substantiated the fact that the reputation of the principal was damaged. It could have been alleged, it could have been a byproduct, but you cannot prove it tangibly. And again, my opponent cannot also additionally prove that discourse beyond the setting, the interlock setting between the faculty actually occurred. He cannot prove that discourse independently has occurred regardless. I would just like to bring forth a previous case or the previous ruling that we have made before concerning the role at which discourse had played. And again, I will read that promptly to you all, if I can find it. Okay. So the discourse that was alleged and that was supposed a byproduct of what the defendant had insinuated wasn't actually occurred, given the fact that multiple witness testimonies have affirmed the stability of the school post-incarnation. If the autocratic statement had ever induced some sort of tangible harm, then it would have been either quantifiable or recognizable. But again, bringing forth to this committee, my opponent cannot prove how harm has been precipitated. We can acknowledge, again, and I'll keep reiterating this statement, you can argue and really affirm demotion, but you cannot assert defamation, because defamation requires post damages or other harm precipitated from a statement. And yeah, I think that is the most tangible rebuttal for the claim. It's just ridiculous and kind of illogical, given the fact that a simple opinion of a tyrannical rule of a principal would constitute $50,000 in loss when you can't even prove losses exist within the first place. And that is where my case rests. Thank you.
Thank you, Mr. Abraham. We will now begin judges' questions towards the defendant.
Could you please just give a definition for presumed?
Presumed, I would say assumed. I think something
Assumed.
that's not tangibly proven yet,
So,
but is assumed, yeah.
could I also ask you to look at the slander/libel lawsuit notes?
Okay. Would you like to start reading it off, or?
Yeah, I'll just, so in burden, in number 4, damages, the statement caused actual or presumed harm to your reputation.
Yeah.
So it does not have to, would you agree that it does not have to presume, it does not have to cause actual harm to Mr. Principal Skinner's reputation to still cause assumed harm?
Yes, of course, but again, as reiterated within my, I guess, rebuttal or opening statement, there has been no basis to validate that assumption regardless. Just because the claim have been made and amplified to the public does not automatically assume that damages have been caused as a byproduct. And again, if so, you must prove job losses after the fact. You must quantify, or you must provide some evidence that would suggest that harm has been precipitated, even if you are presuming it. And that would be my response to.
Okay, thank you.
Yeah, of course.
So I wouldn't classify harm as not just like a job loss. We've heard from testimony from one of the parents that he heard about this defamation, and it at least altered his perception on the school and the principal, if I'm correct. Is that correct? Yes?
Yeah.
Regardless, even if it was just the school, the principal is the head of the school. And if you defame the school and its policies, you are indirectly criticizing the principal. But that's if the principal is not getting defamed, which he is, because the teacher, Miss bless you.
My apologies, sorry.
Bless you.
Thank you.
The teacher is defaming the principal, and by saying that he's autocratic or calling him an autocrat. And the fact that the parent knows this means that the reputation has already been hurt with one parent, and since there's multiple, it's very likely that they will all have the same.
Yeah. So just to answer that point, I am not diminishing the fact that harm to some extent has been caused. But again, regardless, when we are speaking in the jurisdiction of a defamation claim, especially one that accounts for $50,000, you must also prove tangible harm that is per constitutional ruling as well. And just to answer your first claim or your first assumption, I did not reiterate or made the claim that job losses are the only constituent that would comprise rationale for defamation, but rather it is one of many examples that you can utilize. Regardless, you cannot take an isolated testament of one parent and apply that to the broader community of school participants. And again, we aren't diminishing the fact that harm could have been caused, or some extent of level has been caused on the behalf of his reputation, but rather what we are saying is that harm on the scale at which the opponent is discussing, and the harm at which the binding legal contract at which we are discussing today justifies. Again, $50,000 for one parent's testament is ridiculous, and that is a claim that we are making.
So defamation to be considered defamation, the statement has to be said with malice aforethought. So would you agree that the defendant made this statement, your client made the statement intentionally, negligently, or with reckless disregard for the truth? Or do you dispute that characterization?
I would dispute that characterization, given the fact that she critiqued his mannerisms and his administrative policy. It wasn't an attack on the behalf of his reputation or his inability as a principal. It was more so the decisions that he made on that day. And there have been no known accords that she has contended with the principal on previous incidents before this.
Thank you.
Yes, of course. Thank you.
Thank you, Mr. Abraham. That will be all on questions. We will now move to deliberation and finalize this case. Yeah, we have like 2 minutes, so all right. Hello? Where did the plaintiff go? Okay, well, we're just gonna get this. We're just gonna say this. In the case of Silver State Schools, what's it called? Silver State School District versus Portnoy for defamation, we find in favor of the plaintiff 4-1. And we find that the amount is too much, so we're reducing the amount to $5,000. Thank you. And court is adjourned at 3:59 on June 17th.